Tēnā koutou katoa. Welcome to day 3 of hearing stream E on the proposed Timaru District Plan. Our first submitter this morning is the South Canterbury. Oh, sorry, I just got my wrong page up. So we are welcoming South Canterbury Club and Mr. Truman, and you have a co-colleague with you as well. So.
Malcolm Eadie, the president of the South Canterbury Club.
Okay, thank you. Please take a seat.
I can commence, or yes, okay. So thank you for letting us speak this morning. I'm the secretary of the club and have been part of the club for about 7 or 8 years, and as part of my social calendar. Just the club has a long history in Timaru, as you'd have read. It's a private members club that used to have lots of connotations in history. We operate under a King's Charter granted in the late 1800s by Queen Victoria. And there's a document on our wall showing that. There are actually only 32 establishments remaining in New Zealand with such a charter, so it's quite a unique event. We are a small club, and we're trying to survive in this complicated and ever-changing world. And yes, our buildings are old and in need of pressing repair and maintenance. And we're also planning an upgrading of our internal facilities. And on that note, I did see in my original written objection that I alluded to internal, and then I couldn't find Schedule 3. I don't know if you've ever been a novice trying to look at those documents, but I didn't find that Schedule 3 to see that I had no restrictions on our internal, so that part is withdrawn. We have an earthquake risk to the building, and we have signage on the building, so we have a major issue there. We're an asset-rich club, but cash poor, so and which is probably common of a lot of clubs today. And whilst we currently are exploring options on how to raise capital to do the repair and maintenance, it's not a foregone conclusion that we'll be able to achieve this. The committee itself is quite aware of our historical status, and we remain firmly of the view that the classification is actually not befitting to our building. But don't take this as a rejection that we do not respect our historical classification. A recent strategy document prepared by our president unrelated to this, has a vision of our club as the South Canterbury Club, a sustainable future that respects our history. So it is part of our DNA, you might say, to respect. We want to retain the current site and buildings, retain the front entrance and the hallway, retaining the activity areas, the snooker room, the card rooms, and we did talk about the consequences of this historical heritage category B. It was interesting, and we had a strategy meeting last year, and the words, we were looking at the future, and someone wrote on the board 2104. What we were alluding to is that we want to be operating in the year 2104. So we do have this vision of wanting to be, and that's 79 years from now, so I won't be about. So you could then ask, and it's a fair question, why are we against the classification? Sorry, that should be off. Beg your pardon. That's my, yep. Apologies, it's my son. And why, we respect our history. You want to take it out? Sorry, Matt, Malcolm. But we find that what you're trying to ask us to do is a little bit difficult. The main reason is that the additions and the modifications of the original building make, I believe, a 1904 standard outmoded. You have a plan you were given a plan showing the additions we've had. So there's been 7 additions. There was staff quarters added, there was a squash court, a shower and a changing room with a shower and no toilet. There was addition of a ladies' toilet connected to the red room, the ladies' only room up until the early 1990s. We had a room selected only for ladies, and they couldn't go no further than that part, but it's cultural changes. We're happy about that, by the way. Well, we've had two. Yeah, I know. We've had two women presidents, so and I think half our committee today is, half our committee today is female. So, so please, misogyny is not part of our makeup. We have the addition of a snooker room. There was an addition of a meeting room. There was a 2-bedroom flat, and we added the conservatory to the main meeting room in the 1990s. And there's other changes within the building. The snooker room is now a function room, the staff quarters is a card room, and there's minor upgrades to the kitchen with much more to do. So, as noted, the building has significantly changed since 1904. And the original designation, as you're showing on the screen, has that it's over the whole site. And that's what really had us concerned. And we acknowledge Dr. McEwen with her proposed amendment to the PDP. But our calculations show on that classification there that 39% of our original classification are additions to the building, and 61 is the original site. And we know that, appreciate that Dr. McEwen is going to reduce that somewhat, but it's still 26% of the building is the additions after 1904. And it begs the question, at what point does the level of additions and modifications over time diminish the historical nature of the original building? And I just don't know, it's a question I have in my mind, and maybe for yourselves. Dr. McEwen's recommendation shown on her map overlay, and I don't know if you've got access to the her proposed, has a new designation area slicing right through the middle of the flat. Now, I'm not too. Oh, yes. Is the new? Is her recommendation the pink line? Yes. Yes. So that slices through the middle of the flat. So I'm not quite sure how I'm going to apply a 1904 standard to one side of the flat and not the other. So I suppose the question is, how legal is that drawing? And if that is a fact in law, then there's going to be a difficulty modifying the flat.
Would it be helpful if I came up to the board and
no, they show the flat. Okay.
Come around and show you on this drawing. So the club has two types on this. What they have done is just brought it down to this. This building here was a flat construction, I think it's this here is a swatchboard. The original building is, I think, there is additional out here. There has been a there is another diagram plan that's got all of the stages, which I think Stacey will obviously see. So from that you can see additions and alterations have been added for construction. So I guess in summary, our argument is one, that the building has the column is really raised here. If the living but the buildings are removed.
Thank you, Malcolm. Second part of our objection is the historical classification, I believe, puts an undue burden of compliance on the club. The current integration of the structure is integrity of the structure is a major concern, given the repairs and maintenance we do. We have roofing issues where it leaks under a heavy rain. We have painting issues. The sash windows need stripping back and repairing, and there's 23 of those. And we will do that in time, but they are sash windows of the historical part of the building. The remaining guttering needs to be replaced, and we don't have a wheelchair access, which is becoming mandatory these days. Earthquake strengthening has to be done. We're currently at 27%, and we'll need to get up to 34%. So we're looking at ways of doing that, and to do that without altering and putting major steel around the building and making it look horrible is difficult. And we have an erosion on the cliff face to the east from heavy rainfall way back in 2023. And nervous that that's going to undermine our main building. But I do appreciate that HHR4 and HHR5, there's a criteria to abide to resolve those issues. But that for us, it's an additional hurdle that we have to cross. The other part is that we are an incorporated society, and under the new Act, we have to re-register by April next year. The Act has 6 duties for officers, but there's 2 of them that caused me some difficulty. One is not to create a substantial risk of serious loss to creditors, but the one that I find that we could be held under is not to incur an obligation the officer doesn't reasonably believe the society can perform. And there lies the nub, is that I see a major issue for the officers of the club being able to comply with both the demands of the classification and the Incorporated Societies Act. I appreciate this might be outside your ambit, but I just want to raise that as a concern that we have. And my fear is that the tradition and purpose of the building will potentially be lost if we're impaired with a stringent compliance. And eventually, the building could become another hydro. And for those who are local will know what I'm alluding to. An issue that I don't know whether it is relevant to you, but the zoning of our site is residential. And the zoning across the road is commercial B. We are not part of the town centre zone. And I think that's quite relevant. The other thing is that I would venture to suggest that we're on the steepest street in Timaru. And I challenge you to walk up from Strathallan Street to go up to the terrace, and you'll be puffing in 50 yards. It is not an area you can drive past and visually going, oh, there's a lovely building, because you'll run into a car coming the other way. You even driving down, you have to be ultra careful. It is not, from that sense, it's not a tourist location or place you can see readily. In conclusion, thank you for hearing our objection, and we appreciate that our arguments may not be accepted, and that we will have to accept that our request for declassification is not to be agreed to. If this is to be, we would like to see that at least the area of the plan drawn to actually reflect where we stand, because I just find that the way it's drawn at the moment, the flat is of an issue. And drawn that way. So thank you very much.
For that, I'll see if there are any questions.
Thank you, Mr. Truman. And I didn't quite catch your name.
Colin Truman. Malcolm Eddy.
Malcolm Eddy. Thank you both for your presentation today. It's been very helpful, very informative. In terms of the revised area that Ms. McEwen has put forward. So I've understood your concern around with a flat, the line, and that's something we can certainly follow up with Dr. McEwen and Mr. McLennan, who's the Section 42A officer who's written the report, yes. who's not here today, but we can follow up in writing to clarify that.
Thank you.
In terms of the conservatory on the side, you were also concerned that was covered by the original area.
Yes.
Is that now addressed satisfactorily for you with the revised area? It's quite hard for me to see on these plans the conservatory, how it lines up with that line.
Because I can show you on.
Can you show me, please?
But yes,
Yeah.
no problems.
Thank you.
It's that's built in 1990. This little section here.
Yes.
It's an aluminium structure.
It's basically like a sunroom
Sunroom.
being added onto the building.
So on the revised area, it's still included within the... Yes, okay. And do you remain concerned about that? Or was the flat and the tennis courts, the main...
Well, the only issue will be if the clip gives away and it's hanging on a... which is the floor there, that'll be the main issue. But I suppose you could argue, yes, if it's the same criteria as the flat, then that should be outside. Well, it is a straight line from the original building across.
Okay, well, that may be a detail that we check as well.
Okay, thank you.
And my other question related to your concerns around the financial burden that may result from the heritage classification. And I wondered, had you approached the council to understand or discuss any funding support for that might be available to you if the classification was to proceed?
Not at this stage, no. We haven't, not at this stage, no, but thank you for that
Okay,
thought.
okay. I believe, we haven't got Mr McLennan here to confirm, but I believe there is some form of protection fund. Councillor Scott, Commissioner Scott could confirm
The
for us.
Heritage Fund, but it's $5,000.
A building of that age,
Yeah.
5,000 probably wouldn't go very far. We are an asset-rich club, but cash flow poor, and so that's the tension which we have,
Operate under.
and therefore we have a commitment to maintain the building, and that's absolute, but it does put some constraints in terms of the functioning of the club with the obligation of having a heritage status building. We respect what we have and wish to continue that, but the restriction it places on the club we feel is an undue financial burden and constraint. So that's our concern. For us to continue as a going entity, then we actually need not to be burdened by obligations in that way.
Thank you very much.
I just wondered, are you able to provide us with a copy of the club's constitution or the...
Yes, it's available. If you can, I'll send you the link.
Yes,
Yes,
thank you.
It's available on the website. So
Okay,
yes,
thank you.
Yeah, no problem.
Being
It's the 1908 though at the moment. It's on the 1908. We've got to go through to the 2022
Yeah.
Act.
And what you say,
Thank
yeah.
Yes, so the club will need to rewrite its constitution to comply with the new Act before May next year. So
The fundamental obligations around the assets of the club would remain in
Yes.
place. It's more
Yes.
aligning it with the new regulatory requirements for the governance of the club. Is that your understanding?
there are some financial obligations which do change,
Yes.
and the change will be that if the club is no longer exists, then all of the assets have to mandatory go to either an allocated entity, a like entity, and so there are some restraints over that.
Kia ora kōrua. I just have one question. It's about, I understand that you're saying we don't want it to have heritage status, but in the alternative, it's carving out what actually is appropriate. And I do have the diagram in front of me that shows the additions, what came in 1950, 1970, 27. And when I look at it and I go, well, how do you carve this up? And what's really part of the building and what's not? And I do understand the logic in going, the flats could easily be taken out, But then if you go, right, and then the veranda, and then just behind the verandas, there's another 1970 little bit, and then there's a 1920, like, what parts are really part of the building and should be carved out?
Yeah, I mean, my personal view is that the squash courts, the flat, and I can accept the aluminium conservatory. The rest is built in tone with the building. It's double bricked. All the other additions are double bricked, the same as the original building. So there is some sort of synergy there. I think the only difference you'll see is the roof. The roof's got different colour paint. That would be the yeah, but that.
This is a question that we'll get clarification from the council, and Ms. Vella, if you could refer it on to Mr. McLennan and Dr. McEwen. But the structure of the plan distinguishes between heritage items, or the sort of a building that's listed, and then there are rules that apply to the setting. So that's what happens around it.
Right.
So while there are some, and just looking at the list, it suggests that it's the Edwardian villa, single-storey building with L-shaped footprint and multiple roof forms, which needs a bit of clarification in terms of the layout as to what that is.
Yes.
I'll come to that. Is the listed item, but then there's a setting that's been identified, which was now represented by the modified. So there are rules that would control if you were to put a new building within the setting, and then there are rules that relate to if you were to demolish or modify the heritage item. And I'm not clear in the case of the South Canterbury Club where the club sits precisely. So if, to my mind, you could have a setting that was wider than the actual heritage item, and it may transect existing buildings, but if those other buildings are not of themselves listed as heritage items, they would be subject to different rules than the core building, which might be a listed item. Okay. And I missed the opportunity when Dr. McEwen was with us to actually clarify that. So that will be a question that I have for her, is what is the significance of redrawing the line in terms of the rules? And that might provide an answer in part to the concerns that you have about the line transecting some structures that may not in fact of themselves be listed. So just with that in mind. But if given that description, do you want to approach the map and just
I can show you
say what you think might that refer to, or is it?
You referred to a.
It says Edwardian villa, single.
From the front.
Yes. Single-storey building with L-shaped footprint.
Yep.
And multiple hip roof forms. Yep. So if that's the as opposed to the structures. Yeah. So my question for Dr. McEwen would be, are those additional buildings that now sit partially outside of the setting, further north of the line?
The flat and the squash court?
Yeah. Are they part of that listed item, or are they simply within the setting, buildings that are within the setting? Yeah.
I don't know if Dr. McEwen had that map showing the stages of the development. Maybe good to have that. And we talked about a big high-rise area, and that's that area there.
Right.
It's a big 20 foot
Yes.
start.
Yeah.
Skylights all around it.
Yeah.
Quite a big room.
Jane, I have no questions. No questions? Commissioner? Okay. I think that's it. The panel have no further questions. Thank you very much for your presentation.
Thank you very much.
We'll get a response to those questions from the council. Thank you.
Am I able to make a comment as the president?
Sure.
Right.
Yes.
I think from the club's perspective, we have an absolute respect for the history of the club. Our concern really is the financial burden and obligation which this classification would put the club at risk. If the club was at risk, then the property would go on the open market, and then that puts what is there at risk. We have an absolute commitment to its history and its heritage, and we will try and find funds and maintain what is there. Our argument is that the classification would just put an undue burden on the club, and therefore we would question and request that it not be classified, and so therefore we would look forward to your ruling on that matter.
Thank you. That's clear. We understand your position. Thank you. Thank you for your submission. Ms McCubbin Howell, Legal Counsel and Planning Expertise from Liz Williams. So welcome to the hearing.
Kia ora koutou. Can I just check first that the sound is all working at your end?
Yes, thank you.
Thank you. Kia ora koutou, ko Alice McCubbin Howell ho, he roia mō te papa a te whaia ho. My name's Alice McCubbin Howell and I am Legal Counsel for the Director General of Conservation. Hopefully you will have received our legal submissions and the planning evidence from Ms Williams. So what I propose to do is just take you all through a brief overview of the legal submissions before handing over to Ms Williams.
Thank you.
So as the panel will be aware, the Director General has made a number of submission points in relation to hearing E. Ms Williams will present her expert planning evidence. Ms Williams' evidence and the legal subs both focus on the Director General's submission points that relate to the energy and infrastructure chapter. And more specifically, they provide support for the approach that was sought by the Director General in its submission and recommended by the Section 42A report writer in relation to the adoption of an effects management hierarchy in relation to the management of adverse effects of infrastructure on identified sensitive environments in defined circumstances. So if I take you to the legal submissions, from paragraph 5 down, I have set out an overview of the statutory framework under the RMA insofar as it relates to the protection and management of Indigenous biodiversity. These submissions here draw on the legal submissions that the department filed in relation to hearing D, which was the eco chapter. My colleague Ms Newell presented the submissions in that for that hearing, and I was attending in support on those ones as well. So there is further detail on that framework provided in the department's legal submissions from hearing D. For the purposes of this hearing, the points that I wanted to emphasise are the clause 4.1 in the now operative NPSIB, which requires councils to give effect to the NPSIB as soon as reasonably practicable. This was a matter that was discussed in relation to hearing D around what that requires, and the department acknowledges that what that obligation requires is context specific. I will come to that in relation to this issue as I continue in my submissions. And the other point just to note, which again was discussed in hearing D, was just to reiterate that the most recent Resource Management Amendment Act, which came into force in October 2024 last year, which did have provisions relating to the MPSIB, is not relevant in terms of the Council's obligations relating to Indigenous biodiversity in the context of the proposed Timaru District Plan. So again, that was something that was traversed in Hearing D, but just to reiterate that point again, because it is obviously some time since we were talking about these matters last. So turning just to the 2 points which I've highlighted in the legal submissions. The first is from paragraph 7 in relation to the inclusion of an effects management hierarchy for regionally significant infrastructure and other infrastructure. So in accordance with Ms Williams' evidence, the Director-General supports the proposed effects management hierarchy approach, first and foremost because the Department considers that it's a sensible and appropriate framework for addressing adverse effects of infrastructure within sensitive environments. But also, and this goes back to the point that I made in relation to the legal framework, that from the department's perspective, this provides an opportunity, in part, to align the proposed plan with the MPSIB. And Ms Williams will talk to you in more detail around this, but there is an identified exception in the MPSIB for specified infrastructure, which directs the application of effects and an effects management hierarchy to manage those effects. So the department acknowledges and agrees with the more general observations that have been made by the Section 42A report writer around the general advantages of this approach, but notes as well that this is an opportunity to align with the MPSIB. Ms Williams acknowledges in her evidence that the MPSIB doesn't apply to renewable energy generation or the national grid. She'll take you through her evidence on those points and ultimately why she agrees with what is proposed. And as part of her evidence today, Ms Williams will also speak directly to some additional points that have been put forward in the evidence from Primeport and Transpower, both of which have sought some further refinements to the recommendations made by the Section 42A report writer. So Ms Williams has prepared some speaking notes, which she will speak to and will circulate as well, and that will touch on those aspects of other submitters' evidence. So finally, in the legal submissions, I've just noted that there are, of course, other submission points that relate to this hearing that the Director-General made, and Ms Williams has included an appendix of those points in her evidence. I've not identified any specific legal matters in relation to those additional points, but obviously if there are any other matters, I'd be happy to answer any questions or to come back to you on those if anything does arise. So unless there are any further questions at this point, I can hand over to Ms Williams or take any questions now.
We have no questions for you. Thank you for that overview and refresher on the Hearing D matters. It's something the panel have been working through, so thank you for that.
Thank you.
We're happy to hear from Ms Williams. Thank you.
Kia ora. Can you hear me okay?
We have, and we also have a copy of your speaking notes in front of us, so thank you for those.
Right. Yes, so I'm Liz Williams and I'm a Senior RM Planner at Te Papa Atawhai Department of Conservation. Thank you for hearing me today and allowing me to join the hearing remotely. So firstly, the DG's submission contained limited points related to the provisions covered by this hearing topic. Overall, I generally support the Section 42A officer's analysis and recommended amendments in the Energy and Infrastructure chapter. In terms of EIO2 and EIP2, I support the recommendation of the Section 42A officer in regard to applying an effects management hierarchy approach to managing adverse effects of infrastructure within sensitive environments. I agree that this is an appropriate tool that will ensure a consistent approach is applied to managing adverse effects of regionally significant and other infrastructure within sensitive environments. where there is a functional or operational need for the activity to be located there, and there are no practical alternative locations. I support the proposed wording change to refer to practical instead of practical within policy EIO Objective 2, as recommended in the Section 42A Officer's Summary Report and ECAN's evidence. As noted in my evidence, the NPSAB does not apply to the National Grid or renewable energy electricity generation, but for the infrastructure that is not exempt, I consider that the proposed approach to policy EIP2 and effects management hierarchy approach is generally consistent with the requirements of the NPSAB. In terms of managing adverse effects on SNAs, where it involves specified infrastructure. And I've just included a definition of specified infrastructure from the NPSAB attached to these speaking notes. I support the identification of the long-tailed bat habitat protection area as a sensitive environment, which was recommended in the Section 42A report as well. And I'll just make a few comments on the other submitters' evidence in regard to Transpower and Prime Port. So in regard to the evidence from Transpower and proposed amendments to EIO2, I acknowledge the need for the proposed objective to align with both the NPSET and the new proposed policy recommended in the Section 42A Officer's report for the National Grid. In my opinion, the suggestion is to include a National Grid specific clause within the objective is appropriate. In regard to Prime Port and the planning evidence submitted from Ms. Seaton, I agree that the infrastructure chapter should not take precedence over the provisions of the port zone. The port is identified as a regionally significant infrastructure, and the port zone chapter contains rules that manage these activities. I note that the Section 42A Officer's Summary Report also concurs with this point. I accept that the coastal environment within the port zone is a highly modified environment, and there is a need to recognise existing activities. Although Ms. Seaton has raised issues around the inclusion of no practical alternative locations addition to EI Objective 2, it's my understanding from the evidence submitted that as long as the port zone or the urban areas within the port zone of the coastal environment are excluded from the sensitive environments in EI Policy 2, Clause 1A, that this would address her concerns, as EI Objective 2, Clause 1 would no longer apply. EIO2 Clause 2 would still apply, requiring that adverse effects of regionally significant infrastructure are avoided, remedied or mitigated, having regard to the relevant objectives for the underlying zone in other areas. This is appropriate given that the notified version of the port zone chapter does include objectives and policies in relation to managing adverse effects of the port operational area and port activities on sensitive and coastal environment. And I've just referred to some of those which are from the notified version of the proposed plan. It's noted that the port does include two mapped SNAs, sites 820 and 821, which contain important penguin habitat that was assessed by ecologist Mike Harding in the SNA assessments, which is in the supporting documents. It is my understanding that even with the amendments proposed to EIP2 and the planning evidence by Ms. Seaton to exclude the urban areas of the coastal environment, that policy EIP2 would still apply to the SNAs, which are located at the port and identified in the plan as a sensitive environment. This would be appropriate given that the proposed eco-chapter provisions do not contain exemptions for the port where it relates to SNAs, such as the rules for earthworks in the eco-chapter. This is also consistent with Section 6 matters of the RMA and the NPSAB to protect these areas of significant habitat for Indigenous fauna. I'm unsure as to whether other urban areas of the coastal environment within Timaru District contain sensitive environments. Because of this and for plan user clarity, instead of excluding the urban areas of the coastal environment, I recommend that policy is amended to specifically exclude the port zone area within the coastal environment. I'm happy to take any questions. Thank you.
Thank you. questions?
I do. Hi. My question is around the NPSIB and the infrastructure, and in particular your paragraph 26 and the last sentence you have there, which is alternatively there's an option to form a new policy specifically dealing with REG. And I just wanted to understand, is the key purpose in relation to that so that excluded activities get distinguished? So excluded activities from the NPSIB are acknowledged through the infrastructure chapter? Is that the primary reason that you've put that up for an option?
In my evidence, I was just explaining the other regulations that regulate renewable electricity generation. And because the National Grid is proposed to have its own sort of separate objective and policy, which follows the NPSs that apply specifically to National Grid, my suggestion is that you could have a separate policy also for renewable electricity generation for the same sort of reason.
Yeah. Cool. That's all right. That's just what I wanted to clarify, that was the rationale. Thank you.
No, that's all very clear. Thank you very much for your evidence, and thank you to the Director General for the presentation today.
Thank you.
Thank you.
Those are all the submitters in the first part of this morning. The panel will take a break now and resume at 10:45. Welcome back, everyone. We're resuming day 3 of hearing stream E on the Timaru District Plan. And our first submitter in this session is Mr. Spears. If you can come forward. Thank you.
Good morning.
Welcome, Mr. Spears. Look, just a reminder on the record that Commissioner Scott just noted on our conflicts register that her husband has engaged your services outside of the Timaru district. That doesn't cause me any concern for these proceedings, but just wanted to remind participants of that, and if there are any issues, then they can, of course, raise them with me. But thank you.
Okay. So, my name is Bruce Spears. I'm a cadastral surveyor here in Timaru. Have been practicing in the resource management field for 30 plus years, been a resident for 40 plus years in Timaru itself. So, a number of items in my submission were rejected by your consultants. We'll start with infrastructure, National Grid Subdivision Corridor and the National Grid Yard. What's proposed in the district plan, of course, is well in exceedance of the safety requirements in terms of the code of practice for safety. If you proceed to, is the electrical code of practice, electrical safe distances, if you proceed to introduce this corridor and subdivision corridor and national yard grid, you're leaving yourself wide open, or you're leaving me as a ratepayer wide opening, because what you're doing is you are taking private property rights and you're transferring them to a limited liability company, Transpower New Zealand Limited. If Transpower need those rights, they have mechanism, as they are requiring authority, as are you, to acquire those rights. They just have to pay compensation for them. Transpower uses the planning process to try and progress this. It's a far cheaper option for them than having to pay compensation for land rights. You'll note that, or I will note for you, neither the Ashburton district or the Waimate district include these. They both biffed them out 12 years ago when they made submissions on the same matter. You're leaving yourself wide open, or council wide open, to be sued. And in fact, I think there's Treaty of Waitangi implications in it as well. My advice, don't do it, or else you're going to be in trouble. Okay? So we'll move on from that. Again, in the definitions section, I had a request for the personal services definition to exclude hairdressers, beauticians and photographers. It's not a complete list. There are many personal services, and I will highlight prostitution, which are not listed. Because they're not listed, it implies they're not included. Now, you've got obligations in terms of these. If you remove them, then any personal service is covered. If you don't remove them, the implication is that some services are excluded. I do not read the Section 42A reports. I simply don't have the time. My time went into reading the original 380 pages of the plan and making submissions on those. I don't have time to go through the 42s. I don't know what your consultants have advised you on that one. Again, no one's going to look at the 42A again. It's never going to be seen again apart from when you deal with it today. Once the plan is written, neither the people using the plan or the processing staff will ever go back and look at a 42A to see if it's included or not. It's just so time consuming. It's not going to happen. And so what you need to do is get the plan to be as specific as you want it without any background to it as well. Now, in terms of the subdivision, we've got one here in terms of public access. Sorry, I'm just reading off the sheet that came out. Subdivision is a very significant part of resource management. When you read the headings, and we use public access, PAR1 for example, we're talking about land use, subdivision and development. There's only 3 items there. And subdivision generally is the first one that's listed in any of these, the national policy statements and whatever. You've also got a potential, sorry, I haven't done too much research, grammatical error in this, because at the moment land use is separate from subdivision and development. National policy statements will put a comma in after subdivision, so you've got 3 items and not 2. So you have to be aware. I haven't picked that up until recently when I was reading one of the national policy statements.
So you're comparing the way it's expressed in the Act versus in the
In
national policy statements?
What you've got in the district plan as opposed to national policy. I'm just highlighting it may be an issue. You may have a grammatical error in your district plan. So is it 2 items or is it 3 items you're talking about? Doesn't matter. Subdivision is a significant one in all of this. And if we look at the subdivision section in the plan, it's about 10 pages. And according to all legislation, it's about the most important thing. And so you've got 370 pages of other stuff. Okay? So in terms of when you're talking about subdivision, from my perspective, it'll make it a lot easier if it's all in one place. And that's where we get things like FCR 3, financial contributions, which at the moment are in Appendix 7, well removed from any rules or anything else in terms of zoning or matters that the plan's considering. Personally, I'd like to see them back in subdivision. But again, that's up to care. I can live with it, let's be honest. As a professional, I can skip, and you'll notice I've got a district plan, proposed district plan. All these ones up the top, there's about 15 of them, refer to subdivision, which are not in the subdivision section of the plan. Makes it a pain in the arse, because I've now got to go through 15 sections when I do a subdivision consent application.
Bess, can I just ask, have you, when making those comments, have you considered the national planning standards and what they require, or is this just purely from a user's perspective?
It's purely from I haven't got time to national planning standard. And in fact, I understand there's a standard policy and all the rest of standard format for the document. However, you can follow the standard format. There's nothing to stop a district council going back to that national and saying, we think this needs an amendment. You don't have to follow it absolutely by rote. You can make suggestions back that they've got something out of alignment. And don't worry, I get this with the Surveyor General all the time and his rules. So don't assume you have to do exactly what it says. You can make alterations, particularly in certain circumstances that are unique to yourselves. Okay. So if I move on to the subdivision objectives, my 6655, according to the notes here. There are no objectives for rural lifestyle zone in the district plan, in the proposed district plan. None whatsoever. Which is great from my perspective, because if I fail a rule in a district plan, I then have to go back to the objectives and policies to see if I meet it. If I do, I'm through. If there are no objectives and policies, I'm through. So I can fail rules at the moment in the rural lifestyle zone, and I've got no problems. Well, my clients don't. I'm being a wee bit facetious because sometimes we advise our clients not to do things based on it's not good for the community as such, but the potential is there. Again, I'm sure your consultants have advised you that you don't need to worry about highly productive land as opposed to productive land as currently set out in the proposed plan, so I won't go too far in there. However, you've got a national policy statement that mentions highly productive land, so at some stage you're going to have to address that, probably through a variation once you've got this. Let's be honest, it's still, 3 years away before this is operative? Something like that by the time it's gone through the Environment Court and we've had all the goings on there. Again, subdivision my 6658, public access and esplanades, reserves and esplanade strips, and this is your national format for this again. I don't only consider it's possible to create esplanades outside of the subdivision process. I'd refer you to section 2321 of the Resource Management Act, which specifies that it is able to be done. So it's not, I don't consider it, it's the fact that the Act says it can be done. And on that basis, to have it solely within the subdivision may be a bit of a problem. And again, in the policies, we've also got esplanade reserves and strips in the subdivision section. And again, it's not only possible, it is possible to create them outside of both of them. Esplanade strips do not require survey. They can be done by documentation. So the title can just be notated that esplanade strips are present on waterways. The problem then is which waterways do I identify. In terms of cadastral survey, the Surveyor General requires us to show them as a parcel. So there may have to be some diagram, or you can just do it some other way. What's that for? So in subdivision rules, my 6657, basically it's, at the moment, we are failing a rule. Standard not listed in sub R1 and sub R2. You drop from restricted discretionary straight into non-compliant. It's a big step for a simple fact that you might be 5 metres under in terms of area on allotment. To go from a restricted discretionary to non-compliant is a big jump. Personally, I think it's too big. It's not serving the community any great purpose because of discretion you can decline anyhow. And so, non-compliant just makes it tougher in terms of Is there anything special about dropping 5 square metres? Unlikely, in terms of the whole scheme of things. And so, again, let's be honest, I make money by doing applications, and if I have to spend more time doing a non-compliant activity rather than a discretionary, my client pays for it. Simple as that. So your ratepayers are paying for something that's, to my view, quite unnecessary.
Just clarify, just articulate, so what sort of effect on the environment would we be talking about if there was non-compliance with that standard? Can you give some examples of that?
You have to bear with me while I go back to the... Sorry, it was a year ago I made these submissions or something, and to be honest, we don't go back and review them all the time. So subdivision rules R3. Okay, so we're talking about activity starters with RDIS 2. Where standard 1 is not complied with. The standard 1 is allotment sizes and dimensions. So in a residential area, what's the difference between having a 450 square metre and a 445? Environmental effects are probably zero, let's be honest. Once you get out into the rural zones, the environmental effects, and you'll see in other parts of my submission that I have a problem with the 50 hectare, 40 hectare. Sorry, I think Ashburton's 50, you're 40. Sorry, I deal with 4 district plans basically, and they sometimes get a wee bit, not very much in Mackenzie. Unfortunately, sorry, and as an aside, Mackenzie notified their proposed plan at the same time as Timaru District, virtually, because I live in Timaru, do a lot more work in Timaru than Mackenzie, made no submissions on the Mackenzie whatsoever. Haven't had time. Simply a matter of, so I'm not up with them. Ashburton is 50 hectares, you guys are 40 obviously. The difference between the environmental effects of not complying with the 40, if you're 39.5, what are the environmental effects of that? Again, they're going to be pretty minimal. If you're down at 5 hectares, the environmental effects could be more significant, because at that sort of level you're starting to look at rural lifestyle, which you don't have any objectives and policies for. And in terms of sub S1, the standards of course, 40 hectares, sorry, in terms of highly productive land, the national policy statement is trying to protect those. And there is, at the moment, a class 1, 2 and 3. Government has indicated about a year ago that they'd like to take class 3 out of that, because class 3 is basically the whole of the plains, Canterbury Plains. And in the Ashburton district, it's virtually the whole of the district, except the high country. In terms of that, the national policy statement doesn't give any indication of what area should be considered when you're trying to protect those lands. Ashburton District did some work on this, and in terms of economic effect, they're saying about 12 hectares for irrigated land and 25 hectares for unirrigated land. And here we've got And so this is a discussion with Ian Hyde up there, their district their planning manager. Because I was questioning whether, in fact, in terms of the national policy statement for highly productive lands, you can actually impose such restrictive area requirements on those lands. In addition, the national policy statement is talking about highly productive lands. It's making absolutely no comment on lands of class 4, 5 and 6. Okay? It has no indication that they have any restrictions in terms of the size of allotment you should be creating on those. And without doing the research in terms of what is economic, in terms of highly productive lands and non-productive lands, you really can't be setting strict limits in terms of area requirements, in terms of standard 1. And so again, we're in the situation where we're dropping straight from restricted discretionary into non-complying, which again is, in my view, excessive. Again, in discretionary, you can decline it. So you have to put your case in terms of those allotment sizes. So that's basically it. It's a pick and choose. It's all the rejects that I felt I could make a quick comment on. There's no written submissions or anything. Again, time just doesn't allow it. It's as simple as that. I've got to get Stacey's subdivision
Right. Thank you, Mr. Spears.
consent underway.
Thank you for taking the time to come and see us. I'll just check whether there's any questions from the panel of you.
Thank you, Mr. Spears. I have a question for you on the request you have made to include a new objective specifically dealing with rural lifestyle zone. And I've had a look at the provisions and the chapters and the way in which the architecture of the plan chapters. And I can see that the rural lifestyle zone is one of 3 zones within the rural zone section. So we've got rural zones, which includes the GRUZ, General Rural Zone, Rural Lifestyle and Settlement. And then when I look at objective sub 03, do you have that in front of you?
Sub 03.
That relates to rural subdivision, which mentions the rural lifestyle and settlement zones. So I'm wondering if what you are requesting is actually already provided for in the plan, unless there's something specifically that I may have missed in what you're seeking.
So that's an objective just to maintain contrast between rural environment and adjoining urban. Mm-hmm. And the rural lifestyle zones, I think the only one is up Pages Road, is it not? At the moment?
Me?
Sorry, I think the only one that's listed in the proposed plan is up Pages Road, rural lifestyle zone.
I have to check that detail. I haven't got that on hand at this minute.
I don't believe the rural lifestyle zone has to be adjacent to an urban zone. My view in terms of this, in terms of highly productive land, the periphery of urban zones generally is highly productive land. And so you'll have to go through the national policy statement to rezone it as rural lifestyle. And in fact, I think one of my submissions was that they should delete the existing one because it didn't comply with standard 8 or something of the highly productive lands national policy statement. I can't remember exactly. I don't think you should restrict lifestyle rural lifestyle zones to the urban area. They would be much better located on non-highly productive land. After all, we're trying to protect the highly productive land. And so you get out to the class 4s. So you might have a lifestyle zone that's out at Claremont, for example. We did the subdivision consent for Claremont Castle, and it's class 4 out there. And so you're possibly better to actually put your lifestyle zones on class 4, 5 or 6. So you don't have policy, that objective won't apply in that situation because it's not adjacent to an urban area.
Right, I see. And have you looked at the Te Maru growth management strategy?
Which, sorry?
The
growth strategy.
The growth strategy. Have you had a look at that in terms of the direction that the district has set out for growth?
Yeah, some time ago.
Thank you, but not in relation to these provisions? No. Okay, thank you. Now, my other observation was that, so you have sought in your submission for the subdivision provisions that were in other chapters of the plan to be consolidated.
Please.
And I can acknowledge and see the reasoning behind that request. I do note that in Mr. Boyd's section 42A request, he has accepted that, and he has recommended to us that, along with a few others, I think, that you didn't submit on, that they be relocated into this subdivision chapter. So that's in front of us.
Yes.
And that's something that we will be able to consider. And my last question to you was the definition of personal services.
Yes.
In the transport chapter. I was unclear. I can see the point you're making, that it doesn't specifically point out every possible service that might be within a...
And you can't, so
no.
take them out.
Yes, but my question to you is, what difficulty does the definition specifically present when you're interpreting the plan provisions?
So, in terms of the district plan, it's used by only two classes of people. People that are making submissions, such as myself, and your planning staff, your processing staff.
Yes, so I understood that from your presentation, but I'm interested in that if that particular definition is being interpreted, if you're using the district plan, what is the provision that relates to that definition that you're concerned with?
I have no idea.
Okay.
Sorry, I start at the start, work my way through 380 pages.
No, that's fine. I was just wanting to see if you were concerned with it and it's actually how you might apply that definition in a consenting process or such like, but that's absolutely fine.
No one will look at 42A again.
Yeah, okay. I understand your submission. Thank you.
Thank you. I had a similar question and could see personal services only used once in the whole plan, which was under the loaning standard 7 of the loading spaces. That's where it's used. And then I started to think about, well, the real issue here is the use of the word and. If it was, for example, it totally changes it, right? It's not saying and. But putting that aside, because I understand that, my question is about you have asked for subdivision to be consolidated, but also in your submission, when it came to Rule 7 and the sites and areas of significance to Māori, which is subdivision, your relief first sought seems to be deletion of that rule.
No, I think Rowan asked me this a couple of sessions ago.
Right.
What it is, I asked for the reference to Maori to be taken out. My opinion is, if it's suitable for Maori in terms of the circumstance, why isn't it suitable for everyone else?
Okay, because in the submission here it just says delete SESM R7.
Oh, SESM R7.
Yes.
You'll have to remind me what SESM R7 is.
It's subdivision rules in the SESM chapter.
Okay, so Are there objectives and policies in SASM about subdivision? I very much doubt it.
So with
So if
all the
If you can
others,
give me a reference, which sections is under?
in your submission,
No, in the proposed plan.
so it's in the chapter of SASM chapter R7.
Where's SASM?
Yeah.
Is that towards the back of the plan?
Oh, it's moved.
Sorry?
Oh, sorry, I'm not looking at the... It should be in part two, under the historical and cultural values.
Historic and cultural values.
It's the third section in that part. In part.
And in terms of your submission, it's just one paragraph. It says, if desired, it may be possible to develop and show appropriate objectives, policies, rules, standards, activity standards, matters of control and discretion for subdivision of land shown in Wahitoka, Wahitapu, Waitoka and Waitapu overlay areas.
Yes.
Yeah.
So, at the moment, there don't appear to be any objectives and policies in terms of the subdivision in those situations, in those lands.
It's been recommended to be deleted.
It's shifted
Yeah, relocate.
to relocated. Yes, that's a 42, but I don't understand the request for deletion. Yeah.
Sorry, the only one I can remember about deletion was where a land use adjoined one of the Maori zones. And my view is that if it's good enough for Maori to have that rule in place, it's good enough for the rest of us.
Right, okay, thank you.
Order, commas and things. I'm going to bring up a couple of, well, I'm going to ask you a question about one. So in your paragraph 6.4.9.3, no, it's in the section 42A at that paragraph, you want to replace the word solely with principally. Do you know the section I'm talking about?
This is electricity, I think, isn't it?
Yes, yes, the electricity generated, yes.
Yeah.
So my question is, because there's another principle in that sentence, do you think having two principles would confuse it? Would predominantly be a better word?
Solely's not a good word. It's exclusive, particularly in terms of electricity generation. If it's solely for the use of a property, and we're talking either solar or wind here, then they can't export it to the grid. And that affects the cost effectiveness of installing for a start. Because my son tells me, he's an electrical engineer, he tells me that you can sell it for 17 cents back to the grid at the moment, but we all know we pay 35 cents when we buy it off the grid. So if you're doing it solely for your own use, and I think I did mention this in regard to having hens and eggs or something, wasn't it?
That's my next question.
So you don't want to restrict it to solely,
No.
because it precludes you from using your surplus elsewhere. It goes to waste.
But my question is, do you think using principally along with principle in that same sentence would confuse?
Don't know.
So my question around the eggs one is, do you think you've used the right there?
Sorry?
Do you think you've used the right there?
I don't know quite. Sorry, my wife says my spelling's not very good.
Well, no, I'm only bringing that up because you brought it up about the comma, and I understand,
Yes, yep,
I understand
yep.
why you did that.
Yep.
And I think you're right, because it's a public document and the spelling and the grammar's got to be right.
It does. And
Yes.
yeah, I apologise if I got grammar or spelling wrong, but that's always a possibility, I'm afraid.
but that's all the questions I have. Thank you.
Thank you, Mr Spears, and as with your previous presentations, we're grateful for your attention to the provisions in the plan and to help us improve their usability, so thank you.
Right, thank you very much.
Ms Swartz and Mr Hunter. Thank you. Welcome today. Just before you get underway, I just wanted to mention the site visits that the panel's got scheduled, and just wanted to check in with you that you'd been in communication with Ms Hamilton about the proposed itinerary and whether you're comfortable with that, and if there's any other information that the panel needs to know about your property, that would be most helpful.
Okay, no, we can discuss that now. I won't be present tomorrow, but Sean will be. The rock art is not particularly accessible from our side of the property. We can take you to the edge of the bluff and the beginning of the planting, and in my presentation it'll give you a wee bit of a oversight as to what we've got. But we can show you the area that we would like the overlay removed from, excuse me. And we also think that it's quite a good opportunity because from our property you actually overlook the Taniwha Gully, which you may or may not be aware that the Te Ana Rock Art Trust are doing an extensive replanting and preservation, and it's actually very impressive, and we would recommend that you do, if you do get an opportunity to go and have a look and speak with the main caretaker, Phil Brownie. We strongly recommend that you take that opportunity because it's a very, very good example of doing things right in our view. And also they'll be able to give you a bit of a background because Phil, he's been heavily involved with communication with other landowners as well. You had presentations from the Limestone Group yesterday, and and they've been extremely helpful with regards to our situation as well.
Okay, thank you. Look, just to clarify, the purpose of our site visit is to give us context, and we're more than happy to take your suggestions as to what we would look at, and also assistance for access and ensure that we're appropriately health and safety, but we're not seeking additional commentary beyond what you present to us today in this process, but thank you.
So you will have to drive onto our property, and then it's paddocks. For those that are reasonably mobile, if you pop some gumboots, not a long walk at all, and for those that are not mobile, we can pop you in the four-wheel drive and take you up. Tomorrow we will be having a contractor up there cutting hay. Hopefully he will be gone before you come. And the only other request we've got is that if you wish any photos to be taken, that we take them for you. Okay?
Be taking photos, don't worry about that. And look, we'll liaise with you once we've got a clearer picture of our timing, and perhaps we can make contact and make sure that the way is clear for us to access safely.
Well,
thank you.
I'll give Linda Sean's phone number because I won't be available tomorrow, so they can liaise with you. You're quite happy with that?
Okay, thank you.
Right. Okay. Firstly, we would like to extend our greetings to the panel and thank you for your time in considering our submission on the proposed district plan. By means of a brief background on our property and situation, we would like to introduce ourselves. We are Sean Hunter and Lisa Swartz, and we own a 17-hectare property on Opahi Road, which we have owned for just over 8 years. We are presently running a small sheep stud on the property, specialising in preserving 2 rare breeds of sheep and producing high-quality fibre for the handcraft market. Approximately 1 hectare of this land adjoins Taniwha Gully and has limestone cliffs, a wetland and an archaeological site consisting of rock art and the remains of an... We have put significant effort, time and money in clearing this area of exotic weeds and replanting with native vegetation in line with Te Ana Rock Arts Trust's efforts in the same gully. In order to protect this area, in perpetuity, we have also had Wāhi Tūpuna recognition from Heritage New Zealand and a QE2 covenant placed on this 1 hectare portion of our property. Of note, the QE2 Trust states it costs about $100,000 per hectare to restore native vegetation, so not a small financial commitment on our part. The QE2 covenant and Wāhi Tūpuna recognition were done in consultation with experts in the areas of covenanting and rock art preservation, and was done in conjunction and in consultation with Te Ana Rock Art Trust's application for Wāhi Tūpuna and their own QE2 covenant. As you can see from our actions, we agree with the principle that these archaeological and significant natural sites need protection. Today, we are here to defend our submission on the PDP that the Sassam 9 area placed on our property is excessive and unjustified and needs to be reduced to fit within the covenanted area. We will also be taking the opportunity to rebuke the opposition to our submission and recommendation by Liz White and the entity that identifies as Ngāi Tahu that the panel rejects our submission. Firstly, we would like to address the lack of consultation by the council with us, the landowners, on this issue. We would like to express our disappointment with the TDC in constantly avoiding answering the requests from us and other landowners to explain why we were not consulted prior to the plan being notified. The only official answer we got was you've been given the opportunity to submit on the PDP. This is not consultation. Consultation is where you engage with the affected parties and discuss the issues and ask for their input. This has not happened. We find this lack of consultation deeply, deeply troubling. This lack of consultation also appears to concern Ngāi Tahu, and I refer to John Henry's report, Appendix 3, where he states that, I note that Ara Whenua had indicated a preference prior to the notification of the plan for landowners and or the general public to be given the opportunity to learn about cultural values and traditions if they wished to do so, rather than see Maori terms in a statutory planning document for the first time. Like ourselves, many other landowners that have been affected would have welcomed an open discussion with these interested parties. Cooperation from the landowners is critical for a policy such as this to actually work. Again, I refer to Mr Henry's report where he states, Kāti Huarapa are mindful that in seeking to protect these sites that some landowners who are already doing their best to protect them have become upset because the overlays have been identified on their properties. For me, it is not enough to rely upon their goodwill, especially when there is no guarantee that the sites and areas will be protected into the future if the properties are unsold.
This is what, thank you for bringing that to our attention. We've had conversations with the other landowners around that correspondence, and that, just to assure you that we have a copy of that correspondence on the record, and that we're well appraised of the concern that landowners have had regarding the process leading up to notification. I'd really like to encourage you to utilise your time today to talk to us about the impact of the rules in the plan on your property. But just be assured we hear what you say. Thank you.
All right. Okay. I'm just going to say what I'm going to say because it still keeps the flow of what I've got to say. Whilst we agree with this statement in part, and it is one of the main reasons why we had a QE2 covenant put in place, however, we also find it a fundamentally flawed idea that Mr Henry and his associates think that by relying on a policy put in place by a district council will afford real protection for these sites. This brings me to the actual restrictions that have been put in place on ours and other affected properties, and the flawed process that has been followed to determine these. The one-size-fits-all approach is not going to work given the diverse topography and geology of these affected areas encompass. Again, I refer to Mr Henry's report where he states, I understand that some submitters questioned whether the Sassam sites have been ground truth through site visits. And I won't read the rest of his statement because you are aware of that.
Well aware of the statement prepared by Ara Whenua.
So this is a totally unhelpful approach and shows the lack of importance that the council, Mr Henry and his associates have placed on getting the right solution that is going to work. Furthermore, this emphasises the need for the council to consult with the landowners who have an intimate knowledge of their land. The council have not provided any evidence that the restrictions that they have put on the affected areas are actually going to protect the areas, and that the farming activities currently in place are in fact accelerating the natural degradation of these sites, and in our case, the rock art. I refer to the Maori rock art and associated freshwater taonga protection, a science-based knowledge convergence approach report. This report has a lot of theories and pretty pictures. What it doesn't have is cold, hard data with measurements that are relevant to the limestone areas it discusses, or the different geological and topological features encompassed in the affected areas. No data equals no evidence, and this report would not stand up to scientific peer review. The buffer zone put in place, presumably based on recommendations from this report, on approximately 2/3 of our property is excessive and unjustified. This lack of evidence negates the specific response to our submission by Mr Henry in his report. He simply has no evidence to justify his response that the overlay that currently encompasses a significant portion of our property should remain in place. We also question that the entity Ngāi Tahu have any legitimate interest in the archaeological site located on our property, and potentially many other sites in the district. I now refer to documents by Heritage New Zealand provided to us when we obtained Wāhi Tupuna recognition, and the Stuff article dated 21st of October 2021. I will be providing those to Linda post this presentation. In the Heritage New Zealand document, it states that Ngāi Tahu didn't come into existence until the 18th. The majority of the rock art sites in our area were from the Waitaha and Rapawai tribes and predate Ngāi Tahu. This has been confirmed by a conversation with a member of Waitaha we had when we bought our property. Mr Henry and his Ngāi Tahu associates claim to represent all of the tribes. However, it is known that Waitaha don't consider themselves
Ms
part...
Wards,
Yes.
look, we've had this issue before with other submitters. So the report Mr Henry has signed off on is a report prepared by Aoraki Environmental Consulting in his capacity as a consultant to that organisation. So it's not helpful to refer to him as Mr Henry and his Ngāi Tahu associates. If you're referring to documents, please refer to them correctly in terms of the organisation under which
So
they have been
I refer
issued.
to the documents provided by Aoraki Environmental that make the claim to represent all of the tribes. However, it is known that Waitaha don't consider themselves a part of Ngāi Tahu, and I refer the panel to the Stuff article dated 21st of October 2021 as a concise summary of the situation. As far as we are concerned, this fact alone casts a significant shadow of doubt over whether Ngāi Tahu are the appropriate group to be consulted on the areas of significance, and they are most certainly not mana whenua as far as we are concerned when it comes to the archaeological site on our property. The PDP in its present format severely impacts on our rights as landowners to carry out our day-to-day farming activities. To have to get permission to carry out standard farming activities is insane, and to have approximately 2/3 of our property affected is significantly and consequently negatively impacts our income. While we understand that some of the current restrictions have been recommended to be removed, it still hasn't happened yet. The zoning of SASM and SNA significantly devalues the affected properties, which has already occurred on the West Coast. We would not have purchased our property if the SASM overlay was on it at the time we bought it. With regards to this, the Timaru District Council needs to carry out the necessary duty of care with regards to Section 32 of the RMA. This clearly has not been done. So in summary, we believe our submission should be accepted and the responses from Aoraki Environmental be rejected on the following grounds. The SASM overlay on our property is excessive and unjustified. 2, the lack of landowner consultation. 3, there is no evidence that our current farming activities are causing damage over and above the natural degradation of the rock art, and that the restrictions that are now in place are going to prevent any further degradation. There is no substantial evidence that the group identifying as Ngāi Tahu have a legitimate interest in the archaeological site, given that it predates the existence of Ngāi Tahu and is connected with a group that don't identify as Ngāi Tahu.
Thank you, Ms Swartz. I just, in terms of just to, so you know what's been happening in the hearing process to date, that one of the reports that you referred to, I understand, is appended to Ms White's Section 42A report, I think, is appended.
Which report is that you're referring
That's
to?
the Council Section 42A report prepared by Liz White, and attached to her report were two reports that were prepared by, I think we've been referring to them as the TIPA reports, but they are a collaboration, I think, with the Māori Rock Art Trust and others that evaluated the buffer zones.
Mm-hmm.
I'm not sure if that was what you were referring to.
Well, I was referring to the report.
We've got the AEC report that was prepared prior to the plan being prepared. I think that's 2020.
I'm unsure, I can't.
And a
I'm
letter.
I'm sorry, I'm not aware of which report you were referring to.
So my misunderstanding, I had thought that you were referring also to, when you talked about the evidence or lack of evidence justifying the extent of the SASM areas, there's a report attached to Ms White's report, which is her Appendix 5A and 5B, and there are two reports that were prepared in 2018 and 2019 evaluating the risks to rock art of different activities. You may have seen
I'm
those.
aware of those. They are what I'm referring to. There's no data.
Yeah.
There are no measurements, there's no data.
And just to reassure you, we've asked Ms White to provide us some more information about also the origins of those reports and the purposes for which they were prepared and how they assist us in relation to the Timaru District Plan. So we are seeking further information about those reports, and obviously we will evaluate for ourselves whether we consider they provide a sufficient evidential basis for the extent of the sites and areas of significance.
Okay,
So that's really just merely to let you know that the panel is onto some of these issues that you have raised around the veracity of the evidence. But of course, that's a matter for us to evaluate in our process.
I understand that.
Now, I'll just see if there's any questions from the panel.
Thank you for your presentation. I am interested in how you use your land and what specific concern you have about the overlay in terms of what activities you perceive may be impacted.
Okay, so initially, and I'm under the understanding that some of the livestock management restrictions have been recommended to be removed. That's one issue we've got. The other issue is the forestry. Now, given that some farming activities are now becoming uneconomic, some farmers are looking at carbon farming, and there is a type of carbon farming where it's actually in conjunction with livestock and trees. So you basically plant the trees at a set density where you're not impacting on the grazing area, and that you can actually graze animals underneath those trees. So those restrictions, those forestry restrictions, I mean, it needs to be clear what you define as forestry, as in planting densities, species, because species have a huge impact. You'll note that pine species, and there's various species, are now causing huge problems in the Mackenzie Basin, and also I notice in North Canterbury they're actually having pine incursion into established native blocks. So those are the sorts of things that need to be, I think, further researched and clarified, and I think just having a blanket restriction on forestry is unhelpful. And also, the biggest concern we've got is as soon as you, and I mean, I don't wish to be sounding racist, but this is the feedback we've had when we purchased our property. Why would you want to buy something that has got Maori rock art on it? It's going to be a problem. People see it as a poison chalice. So if we go to sell our property, it will be significantly devalued. And we were present at a meeting where Jamie McFadden from Groundswell presented, and they actually discussed some of the issues that had occurred on the West Coast with regards to these overlays devaluing property and making them unattractive for people to purchase. While it's an unpalatable thing that I'm saying, it is a reality.
Okay, well, thank you. I've understood your concerns in relation to the potential future use of your land. We have explored the issue of property values with some of the submitters. It's not necessarily something we can take direct account of, the value of a property, and we have no hard evidence being presented to us from a property valuers as part of this process. But yes, I've certainly kind of noted your concerns about their future use. Thank you.
Kia ora kōrua. I have just two questions. My first question is about Rule 5, which is mining and quarrying, and wanted to know if you have any intentions to mine or quarry your land.
Well, unless we find gold on there, probably not.
No. So that rule's not a concern?
No, it's more what we would call standard activities. I mean, mining is not really something you would associate with farming practices. The planting of trees and orchards and carbon farming and livestock and the associated earthworks such as digging fence posts, putting in yards, putting in animal handling facilities, those sorts of things. They're the sorts of things that we, potentially would happen on our type of land and on our neighbours' properties as well, which have also been affected.
That's really helpful, and I think you've described really well what types of activities you do, so we can really understand how this rule framework would impact. And I just also wanted to note that the status of Kati Hurirapa as mana whenua is not a matter that's for this hearing, that's not in dispute for this hearing, and any evidence that's received on that is an irrelevant matter that we cannot consider.
Just got one question. Around the QE2 area that you've shown on your certificate of title, can you just provide me with a bit of a description of kind of like what you would actually, like what you would see where,
Okay.
like, because you talked about it, it's bigger than just the limestone, you've got some planting and things. I just want to understand kind of if when we have a look, what would we, when we go on site, what will we actually be seeing, what might we see?
Basically, you won't see much because unless you actually physically walk down into the area, because our planting has actually established quite well.
Right.
And we're quite pleased about that. So basically you'll be going to the fence line and there'll be just trees. You will be able to see an example of something similar when you look across the gully into the portion that the Tiana Rock Art Trust manages. So while it's not the cliff face, it is something similar, and you'll also see the wetland below.
So approximately how far from in terms of where the rock art actually is, then just distance-wise, in terms of where you've done the planting and your wetland?
Okay, so there's actually a buffer zone between the cliff face that has the rock art on it, and I would say how many metres that would be in some places, 30 metres. The fence line sort of follows the contour of the land. I mean, the other thing that is quite prevalent, and you'll see that when you go and do the site visits on the limestone country, is that we get a lot of slips. So the plantings that we're putting in are also protecting those cliff faces from further degradation by the slips. And I mean, we've got no issue with buffer zones, But what we've got an issue with is this one-size-fits-all approach. I mean, some areas you may need, because I know that some of your submitters have spoken about a 10-metre buffer zone. In some situations, that may not be enough. At the end of the day, each site needs to be assessed on its own merits, because it is, you know, we've presented, we actually take this seriously, and it's quite important, it's not quite important, it is very important that we get this right. And, you know, you'll see when you come to the visit, do our site visit, that the buffer zone is really quite excessive, because any sort of danger to the rock art we've dealt with the fence line and consequently the surveyed QE2 area, we believe is sufficient to protect that.
That's really helpful. I just wanted to kind of understand the context of your QE2 area, and so that's very helpful. Thank you.
No questions.
I have no additional questions. Thank you for your presentation, and we look forward to also receiving the bundle of documents that you've referred to regarding the QE2 Trust. But thank you.
Okay, thank you.
Ms Francis for the Canterbury Regional Council.
Kia ora koutou. Ko Deirdre Francis toko ingoa. I'm basically here today to provide an opportunity if any of you have got questions about my evidence. I have nothing further to add to the evidence that I produced following the Section 42A report.
Awesome.
Can I just clarify with you, your paragraph 37?
Sorry?
Your paragraph 37?
37.
And it's just regarding the CRPS does not contain specific policies on functional need or operational need.
Yep. Basically, after searching through the RPS, there was not a specific policy on functional need or operational need. It's encompassed within other policies, but it's not a specific.
Great, that's what I just wanted to understand the context, because what I was looking at in particular was in the energy chapter around infrastructure, so I just wanted to be very clear.
Yeah.
So it's not that there's no reference at all to functional need or locational need, thank you, that's clarification helpful.
Thank you. At paragraph 59 of your evidence, so you have expressed a concern that the current list in E1 P2 lacks certainty.
Sorry, I've got the wrong paragraph. What paragraph?
Oh, 59?
59. That makes more sense. Okay, yes?
Can you please just talk me through your impression of the uncertainty created, in your view?
Need to find the... So if we look at EIP2, and we have the list of those areas.
Ms Francis, could I just get you to pull your microphone around? Thank you.
Apologies.
Thank you.
Right. So, for example, the coastal environment is quite a broad concept, and it's not linked to any hyperlinks, but if you look at my appendix, which one is it? Appendix 3, where I've compared sensitive environment to the EIP2, there are a number of things that could be encompassed in that, and I think just to provide certainty for a plan reader, if there were hyperlinks to what was covered under coastal environment, I think it would create a greater degree of certainty for people looking at it.
At the end of that clause, E1P2 1A, there's a broad statement in accordance with the relevant Part 2 district-wide provisions applying to those areas. Does that assist, or is that not sufficient?
From my perspective, I just think it would create greater certainty, because if you're not a planner or you're not familiar with the plan and you're looking at outstanding natural landscapes, outstanding natural features, high naturalness water body areas, if you could then hyperlink, particularly where there are maps or schedules within the plan that are explaining what's actually covered by them, I just think it's a lot simpler and clearer for a plan user.
It's far more, you're suggesting it just needs to be far more explicit and just looping through to precisely which sections. Okay, thank you. At paragraph 67,
Yes.
You are in support of the Section 42A officer in recommending adopting the effects management hierarchy approach.
I am.
So that's in relation to the energy and infrastructure chapter, is that correct?
No,
Yes.
that's in relation to the infrastructure chapter.
Infrastructure, E1, yeah.
Yep.
Okay, so we've had a bit of a discussion. In your last sentence there, you've said you believe that this approach supports and considers it will help the plan give effect to the NPSIB. And DOC has suggested in their legal submissions that it's an example of where the effects hierarchy could be included in the plan and therefore given effect to the NPSIB.
Yes.
I did ask Mr. Willis about this, and he, in his view, he was including it as a tool in itself, as opposed to specifically giving any effect to the NPSIB.
Yeah.
Do you have any comment on that? Because we're still, after hearing D, in terms of the eco chapters, it's still a live issue for us, and I would be interested in your thoughts there.
I support what Mr. Willis has said, and I also, having listened to Ms. Williams this morning, I agree with her that there is, that it's both. It provides a very clear tool for how the Timaru District Council is giving effect to the direction from the RPS, because it makes it very clear what's meant by mitigating and remedying, so that you've got the steps that you work through. But I also agree that the MPSs trump that. So where the MPS has excluded reference to the effects management hierarchy, that would take precedence over this.
No questions.
That's all very clear, and thank you very much for your presentation.
Thank you.
So we have another gap in our proceedings. A longer lunch break
What is it?
for everyone.
It is 2.
Ms. Vila is not on the road. That's right. We'll, you right?
No, Ray had her speaker on.
Oh,
Just like.
no, that's right. Look, we will take the lunch in adjournment, and I just signal that I'll catch up with Ms. Vila when the last submittal this afternoon is heard, and then we'll have a bit of a check-in in terms of some of the matters that have arisen out of the last 3 days of hearing. But yeah, thank you. We'll be back at 1:15. Thank you. Welcome back, everyone. This is the final session of hearing stream E on the proposed Timaru District Plan. The first submitter this afternoon is Prime Port Limited and Timaru District Holdings Limited. We have folks online. Thank you. Who's taking the lead? Is Mr. Karen Sayer in the room? Yep, there he is. Look, we'll hand over to you. Perhaps just a little bit of background, just acknowledging that you were prepared to travel to Timaru today, but at the panel's suggestion are joining us online, and the primary reason for that is that a large part of your submission today relates to the stormwater chapter, and through some concessions, I guess, made by Mr. Willis in the opening hearing, the panel would like to see expert witness conferencing on the stormwater chapter, because it appears as if there could need to be some reworking of those provisions, and it's our preference for that to take place before we have any detailed questioning on those provisions. So that's just a little bit of background, and we hand over to you, Mr. Karen Sayer.
Tēnā koutou katoa, and thank you, Commissioners, for the opportunity to appear before you virtually today, and for the early notice as well. Very much appreciated. Just as in terms of housekeeping, you will have my legal submissions before you. Our witnesses, 3 of them today, Tony Cooper and Owen O'Neill and also Kim Seaton, have prepared summary statements that have been emailed to the hearings administrator, so hopefully you'll have them before you as well, so you don't have to write down notes too quickly. Yes. So in terms of the intention today is I'll just provide a skim through the highlights, if you like, of my legal submissions, followed by Tony Cooper, who will provide his evidence, then Owen O'Neill and Kim Seaton will wrap up at the end. So in terms of what else is relevant for this hearing, just want to mention that we've got 2 other bits of evidence provided in previous hearings that are relevant. In hearing A, Fraser Munro, who's also available in case you had any questions, gave evidence again about the regional significance of the port, how it's a lifeline utility, and he also talked about the health and safety concerns associated with operating in the port area and why it's important to exclude public access and Esplanade provisions. And also Tony Cooper provided evidence in the last hearing D, where he talked about major hazardous facilities and the need for fuel storage tanks in the zone, which will become relevant when dealing with reduction of greenhouse gases, which was one of the recommendations in one of the officer reports to have in a policy. So with that in mind, I'll just quickly skim through the main parts of my legal submissions. On page 3, I just referred back to the legal framework outlined in hearing A in my legal submissions there, which I don't repeat. I also set out in section 4 4 main thrusts, as it were, from the higher order documents that are specific to the port. And it's about recognising that the port is there and providing for its safe and efficient operation. Moving on to section 5, that's where I cover the definitions. I simply just wish to point out there that for the definition of urban development, it is still our request, Commissioners, that the definition of urban development be clarified so that the port zone is included there. It wasn't specifically addressed in the summary report by the officer, but it's just something that we still want to see. Other zones are mentioned there. We'd like to see the port zone specifically included and listed as part of the definition of urban development. Moving on to 5.3, we agree that with the reporting officer that if he wishes to deal with the definition of urban area in a future hearing, we're happy to deal with it then as well, accepting that for the purposes of this hearing, references to urban area have been removed, so it's sort of irrelevant for this hearing now. And lastly, 5.4, just wanting to record, we support the reporting officer's recommendations for the definition of lifeline utilities and regionally significant infrastructure. Moving on to the energy and infrastructure chapter part of my legal submissions. First of all, integration with other chapters. As I understand it from the reporting officer, Mr. Willis, we're now in an agreed position about the integration as it relates to rules, and specifically in paragraph 12D of the officer's summary report, he agrees that it's appropriate to exclude port activities from the rules in the EI, Energy Infrastructure chapter. What is still somewhat confusing for me, but perhaps we can clarify by the reporting officer, is the summary was silent about whether he accepts that the port should also be exempt from the objectives and policies of the EI chapter taking precedence. The reason I query that is when I looked at the schedule of the summary report provided by the officer, he mentions that in the first line of his schedule that there's an agreed position, as it were, by reference to Kim Seaton's report evidence, where she does talk about the objectives and policies and how the EI objectives and policies shouldn't take precedence over those in the port zone. So I think there's an agreed position, but it'd be useful to confirm that with the reporting officer.
Efficient, and ask Mr. Willis now to just clarify his position on that.
Thank you, Madam Chair. So, I mean, the port zone was developed specifically to provide for the activities of the port and the associated activities in that location. And with that in mind, I think it's appropriate that that still applies, basically, and that the EI chapters do not take precedence over the port zone rules and objectives and policies.
Thank you, Mr. Willis.
Okay.
And I think on that basis, we're in a agreed position, so I'll just move on to the next one.
Thank you.
Now, at 6.6, I briefly referred to objective EI01, which I think still appears to be an outstanding issue. I'm not sure, but in case it is, we've provided evidence, which you hear from Mr. Cooper, about the need to make sure that if we're going to have an objective that refers to emissions reductions being supported, it needs to be where practicable. And as Mr. Cooper explains in his evidence, it is not always practicable in the case of the port, including the need to provide for tank farms, for example. Moving on to objective EI02 and EIP, policy EIP2, and I'm looking at paragraph 6.8 onwards in my legal submissions. There's still outstanding issues here. At 6.11, it remains a concern to the port that there's a new requirement for the adverse effects of regionally significant infrastructure and lifeline utilities to be avoided in specified sensitive areas unless there's no practicable alternative location. That's too stringent a test. And we're also concerned about the requirement to have a new effects management regime apply to those particular activities. Ms. Seaton gives evidence about that. I summarise it at 6.12 of my legal submissions. So with regards to the phrase, no practicable alternative locations, that new phrase inserted by the reporting officer creates an unnecessarily high hurdle for the port. It's inconsistent with the higher order documents, which seek to provide for the efficient, safe and effective development and operation and maintenance and upgrade of the port. And also, the higher order documents provide for a range of associated activities that have an operational requirement to be located in that environment. And so to have this requirement to also add on to that no practicable alternative locations, it's too high a hurdle. It's inconsistent with the higher order documents. In terms of the new effects management regime, we're not seeking to dismiss the new effects management regime in totality. We just want to exempt at least specifically the port in recognition of the port zone being a particular case, or alternatively, if we're going to include the coastal environment in the list of sensitive environments for this effects management regime to apply, we could broaden that to exempt those parts of the coastal environment that are within urban areas. So if you're in the coastal environment that's in an urban area, or at the very least a port zone, it should be subject to this more nuanced and stringent, if you like, effects management hierarchy. Moving on to 615 and 616, I'm just listing their various objectives, policies and rules. There's no issue between Prime Port and TDHL and the reporting officer. Moving on to Rule EIR26, that's really an issue that I think the reporting officer accepts needs to be clarified. And that is something that Ms. Seaton recommends as well. It's about clarifying what's to be captured by this rule regarding above ground water infrastructure. It seems too broad. It seems to capture things that are just run-of-the-mill like swales and rain gardens. We don't think that was the intention of the rule. I think the reporting officer accepts that, so maybe there's an opportunity there for the reporting officer and Ms. Seaton to discuss how that rule might be tightened up. The stormwater management chapter, probably, to be fair, it's the longest part of my legal submissions because there's quite a number of problems there. I don't intend to go through it at length, bearing in mind that your indication earlier that you would be seeking expert conferencing on this. So perhaps what I can just concentrate on then is, rather than the rules per se and the unworkability and lack of flexibility and clarity, which can be addressed through expert conferencing, if I can just concentrate on the legal issues.
Thank you.
So moving on to 7.3, the first thing is there's unnecessary duplication here. When I looked at the stormwater chapter, it begins with an objective which is clearly concerned about the impacts of subdivision use and development on the council's reticulated network, specifically peak demand not being increased on the council's stormwater management systems, and also concerned about water quality in the council's stormwater management system. That's the objective, and in a nutshell, that objective is fulfilled by the bylaw. The bylaw provides for all of that. It already provides an application and approval process. It provides the council with the ability to consider specifically pre-treatment works to regulate things like quality, water quantity, rate of discharge, the constituents of the discharge. Everything that the council would want to consider under that objective is already provided for under the bylaw. So ultimately, the concern is we're duplicating here. Why do we have to jump through multiple hoops to achieve what the objective sets out to achieve? Hence the submission to delete the entire chapter, because even if you wanted to retain the objective, the method is the bylaw. Of course, I flesh it out a wee bit more in the legal submissions, but that's really the gist of the point. Ms. Seaton also points out in her evidence that it's not just about the bylaw being duplicated by the stormwater chapter, but there's also regional planning documents and regional consenting process for stormwater that already deals with discharges that aren't to council's network anyhow. So to the extent that there might be some way to seek to purport to duplicate that as well, it's wholly unnecessary. The bylaw is there to make sure discharges going into the council system doesn't stuff up the council's system. We don't need a proposed district plan chapter to deal with that as well. I won't deal with pages 13, 14, or 15 of my legal submissions because I anticipate they will be ironed out, hopefully, through expert conferencing. But if I could just touch on the legal issues at 716 of the legal submissions on page 15. The issue arising is that the stormwater chapter purports to include these standards, which, as I said, is unworkable for various reasons. But the standards mention that, or the way they work is, it purports to say that if these standards, which are onerous, can be met, then the council will grant permission to discharge under the bylaw. The corollary, of course, is that if the standards aren't met, you don't get bylaw permission, as it were. The The two issues I've identified are, well, firstly, there's an issue about unlawfully fettering the council's discretion to deal with discharges into its bylaw. And I noticed that in paragraph 50 of the council's legal submissions for this hearing, there's a mention there that the approach is to make requirements in the bylaw which are currently guidance as permitted activity standards. So we're elevating guidance into standards. And in my submission, if you're purporting to elevate something that is used as guidance in the bylaw into hard and fast rules as standards, either through the district plan or in the bylaw, then you're featuring the council's discretion to disapply, if you like, the guidance in appropriate circumstances, and exercising its discretion to still grant permission to discharge under the bylaw. Mr. O'Neill does mention potential examples of that, where you might not want, for example, attenuation of stormwater discharges before it enters the stormwater network of the council, where you're right by the coast. In circumstances like that, it makes sense to let those discharges get out to sea as quickly as possible before upstream peaks come along and want to get through. So, do you want to have a hard and fast attenuation standard that you can't break before you get permission under the bylaw, purportedly by elevating guidance into permitted activity rules and standards? So that's the first issue. We're featuring the council's discretion under the bylaw. The second issue is this is also purporting to be a change to the bylaw without going through the proper processes under the LGA. I mean, if you want to change the bylaw, you need to do it under the LGA, using the LGA consultation processes and also the council resolution process, and notify it accordingly. This is the district plan process, purporting to get around, if you like, the local government procedures for amending a bylaw. So again, that's the second hurdle. So there are big questions here to deal with, which, I think are on top of, if you like, the fundamental concerns we have about the onerous and unworkable nature of these provisions. If you have any questions before I move on, I'm happy.
Could you just be clear if, so in that circumstance, if you were right in terms of those two legal issues, what are the implications for a proposed stormwater chapter in the plan? There should be no standards? What's the residual resource management issue that needs to be addressed in your view through the district plan?
Well, when I look at the objective, I don't identify a residual issue. The objective in my submission is already fully met by the bylaw, because the objective is concerned about impacts on the council's reticulated network, and the council is fully empowered to look after that under the bylaw. Looking at, if we take the usual top-down approach that policies implement the objectives and rules implement the policies that implement the objectives, as it were, that sort of top-down approach, the objective's fully fulfilled by the bylaw. So you could either delete the chapter in its entirety, or you can retain the objective, but the method, you could have a paragraph that says the method is council's bylaw. It depends on whether, and I actually touch upon this at paragraph 720. What was the motivation? I was trying to figure out what was the motivation for the council having this chapter in the plan. And I can say it's unusual. This is an unusual chapter for a district plan. And what I picked up, and I refer to it in 720 of the legal submissions, the Section 32 report, Section 2.2.6, and I quote it there, seems to identify, I call it a practical problem that council appears to have, which is that, yes, they've got a bylaw, and yes, they can grant consent under the bylaw to protect its network, but the practical problem that seems to have been identified is that the bylaw isn't the first document considered when people plan a development. And so you'll see in the quotation there in my legal submissions, what you'll read out, it says, bylaws and service consents are not often the first documents to be considered when planning for a development. solely relying on these documents and or leaving stormwater at the back end of the development considerations has resulted in suboptimal outcomes in the past and will likely continue to do so. And my reading of that is what the council seems to be motivated in, is that they want people to think about discharges into the council's network earlier rather than later. And that's, to my mind, that's a communication and a practical problem that can be addressed. Now, as I understand things at council, and people want to do a development, you've got the building consent process. You've also got a subdivision consent process if you want to go that, if you're involving subdivision. And there are discussions with council officers and forms to fill out and all that sort of stuff. And I would have thought it would be easy enough to have a process in place to let people know at the time of building consent application stage or the subdivision consent application stage that, hey, there's a council network here. If you want to discharge into it, you need to go through the bylaw. The bylaw requires you to get permission. You're not going to get permission unless you satisfy us that the guidelines are going to be met or there's appropriate exemptions to those guidelines to be met. So please think about it now. It's a communication issue. It's a paperwork issue that needs to be addressed. It's not you don't try to address it by changing the bylaw, putting in district plan rules and duplicating processes and that sort of thing. Yeah.
So,
and to now, if the council does still want to alert people through the district plan, an option would be have the objective, but just have a method that says you need application under the bylaw.
could that, no, is there any utility in having that expressed as a permitted activity in its own right?
In my submission, no, because then if you need resource consent, if you don't get permission. I mean, part of the problem, of course,
Okay, that's the exact point.
is the rules are unworkable. The standards are unworkable. They're onerous. But I think you're asking if in theory, if you could come up with standards that were hard and fast, workable in all circumstances, is the utility in having it as a permitted activity? There could be a problem then, because if under the bylaws you get permission, but you don't comply with the permitted activity standards, you still need resource consent, even though you've got a bylaw permission.
Yeah. Well, maybe there is, we'll need to think about that, but we've had discussions with council officers and other consent, other submitters in this process about the utility between an advice note and a permitted activity rule in a situation for activities that are subject to permissions under the National Environmental Standards. And rather than seeking to duplicate the rule is simply an acknowledgement that if you have the correct permissions in place, then you're permitted under the district plan. But if you don't, then there is a resource consenting process to go through. I'm not quite sure I understand why that couldn't be an approach here in the context of stormwater. Because, I mean, potentially, I guess, if you've got no permission under the bylaw to discharge stormwater, that literally probably puts an end to the proposal. Well, I guess that's a question. Or is there any ability to propose an alternative to discharging into the council's stormwater system anywhere in the district? And in which case, if there is, shouldn't there be a consent pathway for that to be considered?
Well, from the port perspective, the port gets discharge consents from the regional council or uses the certificate of compliance route for permitted discharges. So I struggle to see the utility here.
District-wide sense, maybe that the port has a different solution, but we're talking about provisions in a plan that apply across the district, aren't we?
Well, in that case, I'm struggling to understand what the council's objective is, because I'm just working off the council's own objective from the objective stated in the stormwater chapter, which is about protecting its network. I struggle to figure out what a resource consent process would do to protect the council's network when the council already protected this network to reject the discharge under the bylaw. So how much more would a resource consent add to protect the council's network? It achieves nothing in my submission.
Okay, I understand your submission on that. Do you want to move on to the other topics in your submissions?
Yes, I can probably skim through quite a lot of this. In Section 8, I deal with the transport provisions. I just simply want to say there's an agreement there between the reporting officer and Prime Port and Timaru District Holdings Limited. With the subdivision provisions, there's also an agreement there, so we can probably move on to the historic heritage listing.
Thank you.
This is one of those issues where we have Dr. McEwen providing a heritage assessment, which is understood. She identifies heritage values of a particular building, and that is the Seafarer Centre. But the heritage assessment, done from a pure heritage perspective, doesn't account for the fact that there's a certificate of compliance to demolish it. And so we've provided a copy of that certificate of compliance to you and the evidence of Ms. Seaton. And Ms. Seaton also provides confirmation of the intention to carry out or execute, if you like, that certificate of compliance. It allows the demolition of this same building. And really my submission is that, under Section 76.3 of the RMA, you've got to have a regard to effects on the environment. The environment has been defined in Section 2 to include not just the present state of the environment, but how it might be developed in the future. That was confirmed by the Court of Appeal in Hawthorne, and it has been followed in multiple court decisions. I do refer to a recommendation by the Independent Hearings Panel on Plan Change 14, because it very closely mirrors the current situation because it's the same witness. Dr. McEwen there also identified some buildings having historic value. And there were submissions by Kāinga Ora and also Christ College to say, well, hang on, yeah, these have been identified as heritage value, these two buildings, but we've got authorization to demolish them. Don't list them. And the panel accepted on the basis of Section 76 and Hawthorne that, yeah, we shouldn't list buildings that already are subject to demolition, either under certificates of compliance or resource consent. And so in my submission, when dealing with historic heritage, it is necessary for the council to identify whether sites that are being identified and considered for heritage listing are subject to either resource consent or a certificate of compliance for demolition. Because if they are, then those certificates of compliances or resource consents shouldn't be disregarded. They form part of the environment, and the heritage listing should be struck out from the proposed district plan. And so in my submission for this particular heritage listing for the Sailors' Rest, the Seafarer Centre, it should not be listed in the district plan. And the last matter is just to bring to your attention that in August last year, obviously, after notification of district plan, a new certificate of title was issued for reclaimed land. And I understand possibly there's an opportunity in hearing G to deal with this, or some other hearing where urban area is to be considered. But we just want to, if you like, tidy things up, that if you like, the district actually includes reclaimed land. And so it'd be good to just clean that up as part of this hearing process. But whether it's done at this hearing or hearing G or some other hearing, we can address you further at it, but it'd be good to just get an indication as to when would be appropriate to do so. But in any case, the certificate of title is provided in evidence as well.
Thank you. Mr. Karan-Sayre, just in terms of your submission on the heritage aspect and the Code of Compliance certificate. In Ms. Vella's opening submissions to us, she sought to draw a distinction between the Plan Change 14 example quoted there, where the issue was the contribution of particular properties to a proposed residential heritage area, which she distinguished from the situation of a heritage item in a schedule, as I understand, on the basis that the item exists until such time as the certificate of compliance is exercised. I just want to give you an opportunity to comment on that.
In my submission, there is no distinction. They're closely mirrored circumstances. In the Plan Change 14 example, it was, again, a building that that Dr. McEwen identified as worthy of heritage listing from a, if you like, a heritage analysis, removed from certificate compliances and resource consent. So it's the same thing. A heritage expert has identified a building that is listing worthy, as it were, from a pure heritage assessment perspective. And the reason I refer to Plan Change 14 is because Dr. McEwen applies the same methodology. In both cases, she applies her heritage assessment methodology, and in both cases, she did not account for the certificate of compliance for demolition or resource consent for demolition. And so they are mirrored examples. There's no distinction in my submission.
Thank you. And can I just ask you about the use of the term precedence when referring to one particular part of the plan over another, and just from a legal point of view, is that the right word? Are we, I guess it arises in the context particularly of the objectives and policies. If the ports chapter takes precedence over the energy and infrastructure chapter, what relevance do the objectives, or what weighting do the objectives and policies in the energy and infrastructure chapter have to port activities?
Well, I think that, as I understand the use of the phrase precedence as it appears in the officer's version of the EI chapter, the interpretation I would have thought was intended by having the phrase precedence is that in the event that the EI chapter obs and pols provide or conflict with or inconsistent with the obs and pols in the ports chapter, then you ignore the ports chapter obs and pols because the EI chapter obs and pols trump it. Whereas without precedent statements, obs and pols, there's no, if you like, planned presumed presumption that one trumps the other. It gets thrown into the mix, you consider the lot. And then you give weighting accordingly depending on how relevant something is to a particular proposal or how specific it is to a particular proposal. So, it's having the phrase precedent there is essentially saying, in the event of conflict or inconsistency between the obs and pols in two different chapters, the EI chapter one will prevail.
Do you think it might be more user-friendly if that was what was explained, rather than the use of the word precedence? My concern about precedence is it does suggest that you ignore the obs and pols in the EI chapter. And would it be clearer to simply say, exactly as you've explained it, that in the context of port activities, in the event of a conflict between the port zone objectives and policies and those in the energy and infrastructure chapter, the port objectives and policies prevail? More words, but if that is the intention, is that a clearer statement of what the relationship is between those objectives and policies?
I might ask Ms. Seaton to comment about this as well when she gives her evidence, but in terms of the relief we were seeking, and I'm looking at paragraph 6.3 of the legal submissions, it wasn't about one chapter taking precedence or prevailing over the other. It's just to exempt the Port of Timaru from the, whatever you want to call it, precedence or prevailing. That's the sole relief we're asking for. We're not really commenting about whether the EI objectives and policies should prevail or take precedence over the other zone chapters. It's not something we've turned our minds to in terms of the appropriateness of that. We're just focused on the port. So I take your point, Mum. It's like, what is the council's intent there? Prevail, or precedence? What is it, like a trump, or is it an outweigh, or is it a give this more weight? It's a very good question. And from our perspective, whether it's a give more weight or a trump or a overrule, we just want to exempt the port from it.
I understand the port's position, but your comments are helpful, and yes, Ms. Seaton might be able to provide a view on that as well. Thank you. I'll just see if the panel have questions for you.
Kia ora. I just have one question, and it's about the heritage certificate of compliance. We also talked about what Hawthorn case actually meant, and my understanding is that it was looking to see whether a consent to put a building in place could also count as part of the existing environment, and that this therefore is different than Hawthorn because you're not actually assessing whether or not the heritage item is, it's not being assessed against the existing environment. So I wanted to know, how is Hawthorn being used and to further your client's position?
That's a good question. You're right that the facts in Hawthorn are different from this one, but it is the principle that has been applied in multiple occasions that is relevant here. And the Hawthorn principle is simply this. When you're looking at an environment, it's not just the environment as it exists. And what Dr. McEwen has done is she's looked at the environment as it exists. There's a building here as it exists. And the building, in her expert assessment, is that it has heritage value. So she's looked at the environment as it exists. But what Hawthorn is saying is that when you look at the environment under Section 76, which you've got to do when you're dealing with a district plan, right? The environment, which is defined in Section 2 as well, is not just the environment as it exists. You need to also account for the environment as it could be through implementing certificates of compliance and resource consents that are already out there and able to be exercised. And so the environment is deemed to include a building not there because we've got a certificate of compliance that is already authorising us to demolish it.
Right, okay, but here you're...
And so essentially the assessment is, well, yes, there's a heritage building now as it exists, which Dr. McEwen has assessed it as having heritage value. But the environment that you're asked to consider under Hawthorn in Section 76 and Section 2 of the RMA is not just the environment as it exists, but as it exists through yet to be implemented resource consents and certificates of compliance for demolishing the building. It's like, if the building's not there, would you list it?
And look, it is a question for, I think, Mr. Cooper about what's actually happening with the demolition process. But putting that aside, when Dr. McEwen is doing an assessment of whether or not it has heritage values, how is the existing environment taken into account?
It's probably a better question with Dr. McEwen, but if I can try to answer that for you, my understanding of what Dr. McEwen has done is she's been engaged to give an assessment of the building that she sees before her. And the building's there, it exists, and she's assessed as having heritage value that she would recommend be listed because of the heritage value she identified. But what she's been asked to do which is to assess the building that is there before her in front of her eyes, and what you're asked to do, which is to consider what the environment is, not just as it exists, but as it would exist if, a certificate of compliance is implemented, are different questions.
Okay, thank you.
And yeah.
Right, no further questions for you, Mr. Karansayer. In your hands to introduce your witnesses. Thank you.
Thank you. And so next up will be Mr. Cooper. And so he has provided a summary statement which was sent to you, which you'll have before you. And if I could just signal as well, if you had questions that you wanted to ask Mr. Cooper regarding the certificate of compliance and demolition intention of that, it's probably better to ask that of Mr. Munro, who's also available and beside Mr. Cooper, because it's a TDHL, a Timaru District Holdings Limited building.
Thank you, Madam Chair. I'm Tony Cooper. I'm the project engineer at Prime Port, Timaru, prior to that I was the infrastructure manager from 2014. I'll quickly skim through this summary statement. So with regards to the Esplanade exemptions, where we've asked for the port to be exempt from reserve requirements between Upland Street and Talbot Street, I understand from the reporting officer's S42A summary that this has been agreed, which is great news for us. It will allow us to operate safely and have a secure site. I'll quickly jump onto the energy and infrastructure. And with respect to objective EIO1, we made further submissions on forest and bird submissions seeking to include the reference to emissions reduction under this objective. Now, both Prime Port and TDHL fully support emissions reduction within the port controlled activities. However, this is not always achievable. From a day-to-day perspective, the port now monitors its emissions reduction, measuring and managing its energy footprint, and where practical, implements new technologies to reduce this footprint. A good example of this is a recent multi-million-dollar emissions reduction project that has seen the total replacement of the old halogen floodlights within the port, and they've been totally replaced with new LED floodlights and a couple of floodlight towers that go with that. We've also implemented new smart control systems and software, enabling program control down to individual lights. So a smart system whereby we think we are probably halving our energy usage simply by doing that. So that's something we have total control of. Our concern is in recent years, consents and approvals have been required within the port zone for the construction of new fuel storage tanks, tank farms and fuel pipelines. These resource consent applications have been sought or supported by Prime Port. It is anticipated that construction of additional similar infrastructure located either within the port itself or within the general port zone will be required from time to time in the future. I further addressed that in my notes from hearing D. Any resource consent application for new fuel tanks could be seen to conflict with this objective EIO1. Ms. Seaton's submission proposes changing the wording of objective EIO1 to read support emissions reduction where practicable, which we would thoroughly support. I won't go too far into the stormwater side of things, but I just want to provide a wee bit of background. We were talking about the port zone. That's been the focus of our submissions. From a stormwater control point of view, the current port operating area, Precinct 7, there are a couple of minor exceptions for small buildings. We don't actually discharge into the TDC network. We have our own private drainage networks. Any further expansion of the port operating area into the undeveloped areas on South Beach and at the end of the Eastern Breakwater will also require private drainage networks. As much as we would love the council to come and put our drainage system in, it's never going to happen. When we're looking at areas south of the port, they are the areas where we're talking about going into the Timaru District Council drainage system. These are substantially, almost 100% developed areas with large buildings, road and pavement areas, and impermeable storage yards connected, most of which into the current TDC system. Just a bit of background I wanted to provide when you're considering our submissions on stormwater. That's all I have. Thank you.
Thank you very much. I'll just check in on questions. There are no panel questions for you. Thank you very much for your evidence.
Next up is Owen O'Neill. I assume there's no questions for Mr. Monroe while he's there?
We do want to just ask a couple of questions of him, so thank you for that opportunity.
Well, I only have that question that was around the certificate of compliance. Is it what it? No. To know what is the plans for the demolition of that building?
The tenants, the current lease expires at the end of this month. The tenant is moving out, and we've got the asbestos removalists booked in for March, and demolition will follow in June, July. So it's imminent.
Great, thank you.
Thank you very much for that clarification. Your next witness, Mr. Karansayer.
Thank you. Mr. Owen O'Neill will provide his summary statement to you now. Thank you.
Good afternoon, panel. So my evidence deals solely with stormwater issues. I'll just read through my summary of key issues in my evidence summary. I consider that the stormwater chapter in the proposed plan seems an unnecessary addition given the other regulatory controls that Timaru District Council already has to implement their stormwater quantity and quality objectives through the stormwater connection process and the stormwater bylaw. I'm of the opinion that the definition of stormwater neutrality should be altered to delete the references to management of pre-development volumes to no more than post-development volumes. In my view, it's specifically a flow issue, and volume is a management. You manage the volume in order to manage the flow, and that's the crux of stormwater neutrality. I consider that the 30 square metre additional pervious area provision for the implementation of stormwater neutrality provisions in SWS2 standard is very stringent relative to other districts. A change to 150 square metres as per the change made to Table 7, which has already been made, would be consistent with other districts. I consider that based on the supporting memo from WSP Limited, the proposed approach to the implementation of stormwater neutrality and the calculation of storage volumes is very onerous when compared with similar practices in other districts. I have concerns about the ability of most commonly used stormwater treatment devices to meet the minimum removal rates specified in the proposed plan. I also consider it very unusual for this type of technical detail to be included within the text of a proposed plan. I recommend that the contaminant removal standards specified in Table 7 are removed from the proposed plan and standards are incorporated into council design standards or codes of practice. I recommend that the definition of impervious surface is adjusted to better define the nature of impermeable surfaces and include additional common functional uses of, for example, compacted gravel surfaces, which are examples are given within the impervious surface definition, but there are many other examples of compacted gravel surfaces, for example, that are then excluded because they're not specifically named. Just in summary of key issues, I also acknowledge the comments of Mr. Willis in summary statement, paragraph 12A, where he recommends that a review of the stormwater provisions, and I also agree further dialogue between council experts and affected parties would be beneficial.
Thank you for that. I'll check in on questions, but I think we're pretty much going to leave. Thank you for your evidence. We will leave questioning. We'll allow council experts and interested party submitter experts to conference on this chapter to see if you can work through the issues together, and in the event that there's any clarification the panel seeks after receiving that joint statement, we will convene either online or an opportunity at one of the next hearings or wrap-up hearing to discuss it further. So thank you very much for your evidence and your willingness to participate in that further work.
Okay, we'll move on now to our last witness for today, Ms. Kim Seaton, planning evidence.
Thank you. I'll start at paragraph 4 of my summary statement, if that suits.
Thank you.
So, for the reasons set out in my statement of primary evidence, so some of this is a cut and paste from my executive summary with some additional comments. So I'll flick through the stuff that's repeating the executive summary quite quickly. So A is just about the recommendation of the definition of urban development, about the port zone being specifically excluded, which Mr. Karen Sayer touched on. B, in regard to the integration between the energy and infrastructure chapter and the port zone chapter, and you've just started that conversation with Mr. Karen Sayer as well. And there seems to be general agreement that there's a little bit of extra finessing needed just to make clear how those two chapters work together. Just on the question of precedence and the value, and perhaps explaining that a little bit more clearer for the plan user. To me, the word precedence means it prevails, the chapter provisions prevail over the other chapters, and that's typically where infrastructure is concerned, how it works. The infrastructure provisions are specifically to overrule all of the other rules in the zone chapters so that we don't have to worry about building setbacks and I don't know, all sorts of other things that normally come to pass. So the objectives and policies do typically prevail, they take precedence over the zone provisions. Where the port zone is considered, the intention, as I understand it and as I support, has always been that the objectives and policies of the energy and infrastructure chapter would sit alongside the port zone chapter. So the port zone wouldn't override the objectives and policies, they would sit alongside it, because there are still regionally significant infrastructure and lifeline utility provisions that apply. Objectives and policies that sit in the energy and infrastructure chapter that may be relevant. But in most cases, if we're seeking a resource consent in the port zone, it's really the port zone objectives and policies that we're going to be looking at. The rules are a slightly different scenario. The rules for where port activities are concerned need to take precedence. The port zone rules need to apply only to port activities. Where it gets a little bit complicated with the port zone is there is, of course, other infrastructure in the port zone other than just the port. You've also got the rail, you've got, you've got important roads, and you've got pipes and that sort of infrastructure as well. So the rules of the energy and infrastructure chapter still need to apply to that infrastructure, which is why in the introductory statement to the rules I've narrowed specifically into the port activities rules as needing to take precedence. It could be explained better what precedence means. On my reading of it, I understood it, but that was coming from with a planner hat on. when I reflected on your question, ma'am, I thought, yeah, I could see why a layperson might be a little bit confused of what that might actually mean. So some extra words may not go astray.
Just to add in the mix, just reflecting on the structure of the plan, of course, we've got the strategic direction chapter, of which has a number of objectives, of which none are said to be, there's no hierarchy within that, but of course we have objectives that relate to infrastructure and objectives that relate to other activities as well. I'm just keen that if we're using a term such as precedence, we're all very, very clear about where it's being used and why. And if there's a different structure to be followed, whether it's in the strategic directions chapter or the port vis-a-vis energy and infrastructure, that we articulate it in a way that makes it clear if that's different from elsewhere in the plan where particular provisions prevail over others.
Yeah, that's a good point about the strategic directions chapter as well. Yeah.
All right.
Okay.
Continue.
So objective EI01, which we consider needs some further amendments, and that goes to the emissions reduction issue that Mr. Cooper just mentioned. We are focusing really probably on the fuel storage tanks as the really obvious example there, because we know that a large new fuel tank will need resource consent as a fully discretionary activity. The obs and poles will very much come into play. And if you've got an objective there that basically says you need to support emissions reduction, a fuel tank is not going to achieve that. So we've immediately got a point of conflict there. The effects management hierarchy in terms of objective EI02 and policy EIP2, which I've touched on in terms of being unnecessarily onerous for regionally significant infrastructure within urban areas in the coastal environment, and we have focused quite heavily on the urban areas of the coastal environment rather than suggesting that it's inappropriate more generally. And there are particular tensions there, I think, or inconsistency basically with the regional policy statement policies around regionally significant infrastructure. I also have, for similar reasons, unhappy with the no practical or no practicable alternative locations provision in there in terms of creating additional policy hurdles for the port. And just to paragraph F, generally supporting the recommended wording for the listed objectives and policies. And as Mr. Karen Sayer said before, the amendments to Rule EIR 26 about minor above ground infrastructure just needs a little bit further attention as well. It may not actually necessarily affect the port per se, it's more a general issue with the rule, is just it needs a little bit more tweaking. In terms of G, so the confirmation of the mapped urban areas, so I did note quite independently, not with reference to this hearing, I did stumble across the preliminary report for hearing G, which we did not think applied to the port. I just happened to be looking at it. So I note that is in fact appears to be the hearing that we're going to be dealing with the port zoning boundary and the urban area boundary, which is fine. And as Mr. Karen Sayer said, we just like to understand where the newly titled reclaimed land, which hearing, if any hearing, it needs to be addressed in also. I'll skip paragraph H, which is the stormwater management, which we've already covered. And paragraph I, that's just generally around some of the changes to the transport standards, which we're in agreement with, and also the subdivision standards that relate to the Esplanade Reserve exemptions. So all good there. Just in terms of the subdivision rules, R5 and R12, and those are ones that relate to coastal and natural hazards. I had understood that they were being held over to deal with in the natural hazards in the coastal hearing. Certainly they'll need readdressing in that hearing, whether the rules are deferred in their entirety now or whether we simply revisit them. For example, most of the port zone is likely to fall within the high hazard area overlay per the Environment Canterbury definition. We are still working through that issue, which would basically mean that subdivision within most of the port zone would be non-compliant, which under the rule as it's currently drafted, which would be problematic. So I suspect the best outcome would be simply to acknowledge that we may need to revisit those rules, but I draw that to your attention anyway. And in terms of the heritage item, which you've also just had the conversations with Mr Munro and Mr Karen Sayer, I don't want to get into arguments around the application of Hawthorn and those matters. Possibly one solution that I've offered in my evidence is that we simply provide evidence in writing later in the process when that building's gone. Under Mr Munro's time frame, it'll be demolished long before your hearing process closes. That may be the simplest thing. We simply say provide evidence that the building's gone. Worst case scenario, it doesn't go. The certificate of compliance expires in the end of November. If it's not demolished by then, you'll have your answer. That may be simpler.
Thank you.
Moving to paragraph 5, it's just the green. More than happy to involved in further dialogue around those provisions of the stormwater. Paragraph 6, in regard to, and I'll read these out verbatim, these are new reflections, basically having reviewed the evidence of some of the other submitters. So in regard to Objective EIO2, I've reviewed Ms McLeod's evidence on behalf of Transpower and her suggested amendments. Well, Ms McLeod's focus is on the consistency with the National Policy Statement for Electricity Transmission. She expresses similar concerns to what I have in terms of the additional tests that EIO2 now imposes on regionally significant infrastructure and lifeline utilities in sensitive environments. Her suggested amendment to introduce a separate provision for the national grid is not one that I have an issue with, except that it actually doesn't address the issue from the port's perspective. In terms of Objective EIO2, that's also addressed by Ms Francis on behalf of Environment Canterbury. I note that she supports the retention of the wording no practicable alternative locations, and that it's consistent with the NPS for Indigenous biodiversity and Section 5.3 of the CRPS. I agree that the wording is consistent with Policy 3.11, and however, Objective EIO2 considerably broadens the scope of scenarios where practicable alternatives locations, I should also say, need to be considered to well beyond sites where Indigenous biodiversity is a key consideration. I do not agree that the wording no practicable alternative locations is necessary to ensure consistency with CRPS, as the assessment of functional operational need can sufficiently encompass the assessment of location. Ms Francis also supports the Section 42A report recommended amendment to Objective EIO2 to reference the effects hierarchy, as does Ms Williams for the Director General of Conservation. I do disagree with both those sets of evidence for the reasons set out in my own evidence, being that the application of the effects management hierarchy in urban areas of the coastal environment, where that is the only sensitive environment applying, is unnecessarily onerous and, in respect of the port specifically, inconsistent with the CRPS in my view. In regard to Objective EIO4, Ms McLeod discusses the use of the term subdivision use and development versus incompatible activities. From a port perspective, I don't have a strong preference for either wording. In my evidence, I accepted the amended incompatible activities wording recommended by the Section 42A report, and I remain comfortable with that amended wording from a port perspective. However, I do agree with Ms McLeod that the national grid, from a national grid perspective, the wording subdivision use and development is more consistent with the NPS for electricity transmission and with policy 16.3.4 of the CRPS. With regard to policy stormwater P3, and I will touch on this, Ms McLeod has suggested alternative wording to provide flexibility and alternative options for regionally significant infrastructure stormwater connections. If the panel is minded to retain the stormwater chapter, I support the amendments that she has suggested. They're consistent with the evidence of Mr. Cooper and Mr. O'Neill for Prime Port, which set out the alternative methods for stormwater management that are employed within the port zone. And in the port zone's particular situation, policy SWP3 could be said to require connection to a network that in some areas at least doesn't exist. So her amendments would really just make clear that there may be alternatives. And in my last paragraph, I just touch on the fact that there was a marked up version of the definitions chapter attached to the legal submissions on behalf of Timaru District Council, containing recommended amendments to the definitions from hearings A, B and D and the current hearing. I assumed that those definitions, as far as I can tell, are just really a reflection of what's been discussed previously, that there aren't further post-hearing amendments included in there, because the same issues that we raised in previous hearings are still reflected in that marked up version at the moment. Thank you. That's all I have.
Thank you, Ms. Seaton. Questions?
Thank you, Ms. Seaton. With regard to objective EI01, your concerns around in clause 3, the support emissions reduction addition that's been recommended by the Section 42 officer. I wondered if I could just talk through that with you from a plan implementation consenting process point of view. I'm wondering if a consent officer was looking and doing the policy analysis and looking at that objective and policy framework, it would be likely that they would look at the objective along with the policies and then arrive at the kind of in the round view of whether a proposal was consistent or inconsistent? Are you suggesting that they might focus on that clause and give that more weight specifically because it's not met one aspect of one clause of that objective? Is that clear?
No, I'm not suggesting it would be given weight. I'm suggesting you're quite correct. The analysis would be in the round. It would be the port zone objectives and policies as well as the EI objectives and policies. What I'm saying is that in doing that analysis, an officer or an applicant, who's looking at it, would come to that objective and go and focus in on the fact that there's a requirement to support emissions reduction and would note that there's a problem there because it clearly would not support emissions reduction. So, no, I'm not suggesting that would have more weight or override or lead to a contrary or completely inconsistent analysis.
Thank you. So what I've heard is that it's more for a clarity, a plan user and plan clarity point of view, rather than a kind of a risk in terms of the processing of a consent.
There's a little bit of risk. I wouldn't say that entirely. There's a little bit of risk insofar as it could prolong discussions, prolong to and froing between the applicant and the council, if the applicant's then having to try and justify, the fact that it's inconsistent with that objective. So I don't think there's a risk that the whole consent will fall over, but it could cause problems, the processing process.
Thank you, that's been helpful. In relation to EI policy P2, I'm not sure if you heard if you've been online today. We did hear from Department of Conservation, Planner Elizabeth Williams. Have you caught up with her presentation to us?
No, sorry, I was part way to Timaru and then turned around.
Right, of course. I'll just raise this with you. It may be something you want to comment on later. She suggested that in her mind there may have been other urban areas of the coastal environment within Timaru District containing sensitive environments. And because of that, she suggested that instead of excluding urban areas from the coastal environment, which I understand you've put forward in your evidence, she recommended that the policy could be amended to specifically include the port zone area within the coastal environment. Do you have any immediate thoughts on that?
Bear with me a moment. I've got my paper before me. 1 second. So if you attach to my summary statement of evidence, at the back of that was a sort of a summary of setting out the various amendments that have suggested to the provisions in the plan based on my evidence. And in that version of EIP2, I've got the alternatives of outside urban areas or alternatively outside the port zone. So yes. That would be a possibility. I mean, we'd certainly address the ports issues. That's our key concern, is that the port zone is excluded from that area.
Thank you. And just as you were talking, when I went down to the appendix, I could see that very loudly and clearly in red, track right. Changes. So that's great. Thank you. One more question from me. In your evidence in chief, you have queried the phraseology used in Policy 1, EI Policy 1. You were concerned with the phrase providing for as opposed to enabling.
Mm-hmm.
In my understanding of the drafting approach for the proposed plan, provide for or enabling are much the same thing. Are they not different ways of communicating the same thing? What's the key difference there from your perspective, and do you still have concerns over that phrasing?
No, I think in my evidence in chief I said that I agreed that providing for was appropriate. They're very similar. I don't see them as quite the same thing. To me, enabling is more directive. That's the word, than providing for. I see enabling as a slight step above providing for, more encouraging of than providing for, which is simply making provision for. I don't see them as quite the same thing. In the context of EIP1, I'm quite comfortable with the wording providing for. I went through the Section 42A report and I agreed on further reflection that wording was appropriate. So I don't have an issue with it, but I don't see it as quite the same thing as enabling.
Thank you.
Kia ora, Ms Seaton. I just have one question, and it's in regards to EIO2, and it's just making sure that I actually understand your argument with this. So the higher, and I'm talking about the term no practicable alternative locations, and my understanding is the higher order document is the MPSIB, and what you are saying is the MPSIB says no practical alternative location as it relates to Indigenous biodiversity, and therefore by picking it up and putting it in here goes well outside of that MPS, and therefore there is no higher order direction for it to apply here in this context. Have I understood that correctly?
The first part of your statement, yes, that's correct. So I didn't quite understand the last sentence.
So essentially, this term, no practical alternative locations, there's no higher order document outside of an
other than the
Indigenous biodiversity area.
one. That's my understanding.
Okay, thank you.
Good afternoon, Ms Seaton. I'm going to come back and labour EIO1 again, and in fact the same clause, but from a different direction. Well, I don't know, maybe the same direction, but a different way. So what I'm just trying to find, I actually want to talk to you about your suggested resolution to it, and I'm just trying to, sorry, it's been a long 3 days, and I had it sitting in front of me and I moved it, and now I'm trying to find it. Sorry, I'm trying to find your reference in your evidence in chief. Actually, it'll...
Paragraph 29.
That's probably the one. Thank you so much. Cool. What I'm... Oh, hang on, sorry. Right. What I'm curious about would be to understand from you, what type of evaluation do you think where practicable in this context would... What do you see an applicant doing to show or to outline where it's practicable versus where it's not? I'm just curious to understand how this might work, how your solution might work. And I guess...
The solution?
Yeah. For context, I'm wondering, do you see it requiring some kind of evaluation of, is it the type of activity or is it the type of emissions that went into creating the activity? What kind of evaluation might be done?
So from the port's perspective, again, coming back to the fuel tank example, and I have to acknowledge that it's the easier example to use than some other esoteric example. It's pretty black and white. So from port's point of view, let's say the oil companies or the port, whoever comes along and they need another large fuel tank to go into one of the tank farms. It's a fully discretionary activity, and if I was writing that resource consent and I was doing my policy evaluation, then I would be outlining the fact that the fuel tank, yes, it will not in itself support emissions reduction because it will provide for large volumes of fossil fuels, more large volumes of fossil fuels. However, that it needs to go in the tank farm, it needs to be beside the port. It is needed because the fuel is needed one way or the other, and it is not practicable to not have it. The fuel is required. By putting it in the port, I would be explaining that there is less fossil fuels being used by having to truck it from elsewhere if it was set somewhere else. So it wouldn't be a long-winded evaluation. It would be simply an explanation as to why that tank is needed and why the fuel in those volumes needs to be stored there. So like any policy evaluation, it's probably maybe a couple of paragraphs explanation as to why it's not practicable in that case on face value to support emissions reduction.
Right. Are you aware of other district plans that have put an emission reduction supporting in their provisions?
No, I'm not. I haven't, to be fair, I haven't gone specifically looking for it to check. So I wouldn't like to say one way or the other, whether they're there or not. I can't think of something off the top of my head, but equally I can't exclude it.
Cool. No, that's good. I was just wanting to ascertain what your understanding or experience was on that. So thank you.
One question. Yes, Ms Seaton, I've only got one question. Aside from installing new petrol tanks, what other activities might need to be assessed as not practicable, or other activities the Prime Port does that might be deemed not practicable to reduce emissions?
The tank in Venice is the only one I could really think of, and the reason I say that is because the rules for the port zone, and specifically those applying to port activities, are very enabling and quite deliberately enabling. The definition of port activities encompasses pretty much everything the port does other than the tank farm. So I couldn't think of another example, and I can't think of one off the top of my head, that would actually require a resource consent that might then get assessed under that particular under that objective, because most port activities simply don't require resource consent.
Okay, thank you.
Thank you, Ms Eden. I've got no further questions for you. Yeah, that's been helpful, and thank you for your engagement with the detail of the rules, and not just from a port perspective, but also some insights that apply or we can take on board across the plan. So thank you. Mr Carensay, I think that brings you to the end of your presentation, unless there's anything else you'd like to raise with the panel. Thank you very much for your attendance.
Yeah, you're correct, Mum. Thank you very much for your time hearing from us today.
That's great. Okay, well, thank you.
Good afternoon, can you hear me?
Yes, we can, and your clients are just getting seated. Thank you.
Thank you. Thank you for the opportunity to present again. On the subdivision topic, I have had the opportunity to review Mr Boy's summary response and heard his questioning from the panel yesterday. But to start off with, in terms of my evidence, I have to say I agree with the targeted approach for rural lifestyle living compared with the dispersed approach that's in the operative district plan, and that this is quite a change of direction for Timaru District Council. So the new rural lifestyle zone provisions have no precedent in the existing plan. And they're very much linked to implementing or giving effect to the RPS direction in 531 about specific rural residential being attached or near urban areas. But the purpose of my evidence was really where the 2 hectare restriction, if there's on-site wastewater management needed, came from. And I have looked long and hard to try and find the justification, have been unable to. And so that was what was the genesis of my evidence, was without that evidence, it's very difficult to see how that 2 hectares has been arrived at. So Mr. Boyce says it's a good proxy for a proximity to an urban area, but in my experience across multiple plans in rural areas, I don't consider that that's appropriate comment to make, because very rarely do you get reticulation outside of an urban area, and clearly the urban development infrastructure development in Timaru would suggest that that's not necessarily a suitable proxy. In terms of determining what an appropriate area is for a subdivision in the rural lifestyle, there's a range of issues, and there's the spatial, there's the locational, there's the rural character, and the matters of
Ms Wolfe, we've lost your audio. Can you check
Sorry.
that and backtrack just a little bit?
Sorry. So I was... did you hear the bit about being a proxy?
Yes, so we've got that. Perhaps if you start from there.
And then I looked at subdivision R3,
which is the rule that would probably be would be applied in this situation. And there's a long list of matters of discretion that would be applied or considered in the context of any subdivision for a rural lifestyle lot, and including infrastructure, but a range of matters. And therefore, I think limiting a subdivision minimum lot size to 2 hectares without considering these range of matters as a matters of discretion and the appropriate rules is too limiting. And I consider that's the more appropriate framework to proceed about what is an appropriate lot size in the rural living zone. Now, 5,000 square metres may be too small. In many cases, it possibly will. But there are rural lifestyle zones of 5,000 square metres which are adequately serviced by on-site infrastructure. So I'm of the view that a limitation, as in the current plan, is not appropriate, and happy to take questions on my evidence.
Thank you. Commissioner.
Kia ora. I have just one question, and it's in regards to your evidence in chief paragraph 5.8, where you're referring to the Canterbury Land and Water Plan Rule 5.8.
Yes.
And I was trying to understand, that rule says that the discharge is onto or into a site that's equal or greater than 4 hectares in area. And so I didn't understand, I might have answered the question for myself. So I didn't understand how that actually helped or enabled your argument.
No, all I was trying to do was show that a lot of less than 4 hectares would require a consent from ECAN.
Okay, right, I understand. And then in terms of your, what you're saying for the Rule 3 is that if sub 1 is not met, then it falls into a non-compliance status. And
yes,
so the solution would be to change that from non-complying.
Potentially it could be, because it seems if something met the subdivision policy 15, because it didn't meet the minimum lot, it automatically defaulted to a non-complying, even though it met the policy.
Yes, okay, I understand that. Thank you.
Yes, Ms Payne, my question relates to your... Sorry, Ms Wharf. My question relates to paragraph 10.44 of your evidence in chief. It refers to subdivisions. It's a standard where you've asked to have included in areas in proximity to urban areas 5,000 square metres. Has in proximity been defined?
No, and this was in response to an issue that Mr Boyes raised about maybe there's a case for differentiation in lot size closer to the urban area than other areas. However, I do note that the RPS is that rural residential should be attached to urban areas. So the fact that there are rural lifestyle areas further away, not attached, actually raises some issues about giving effect to the RPS. But aside from that, proximity, adjacent to, or not attached to could be a more appropriate term.
Would in proximity be specific enough for a standard?
No, I think there is a question about whether that is specific enough, and as I say, it could be in areas not attached to urban areas
I understand.
rather than in proximity to.
Okay. Thank you.
Thank you, Ms Wolfe. I've got no further questions for you. That's been helpful. Thank you. And I just acknowledge Mrs Payne and David here today. We're not expecting to hear from you today, but note your presence. Thank you very much. Thank you.
Thank you.
Final submitter of this hearing stream, Transpower. So we have joining us by video link, Ms Ing and Ms McLeod.
It's only two of them.
Thank you very much. I'm not sure if it's lucky last or graveyard shift. Look, I'll just jump straight into a brief summary in response to the summary statements you've received from the various in relation to the various 42A reports. But first, perhaps I'll highlight the rather lengthy attachment A to my evidence that records substantial agreement in relation to a number of Transpower submission points. I don't address any of those matters further today, but it's very lengthy and there are a lot of pages, so there are only a few outstanding matters that I need to address today. Turning first to cultural values, I've read the summary statement in relation to this, and I don't think there are any remaining areas of disagreement between myself and Ms White. And in that regard, I agree with the cross-reference to EIPX being included in SASM P5 and P7. I also agree that the rules include a matter of discretion that references the benefits of regionally significant infrastructure. Now, turning to the infrastructure chapter and the outstanding matters that are identified in Mr Willis's summary statement, I start first perhaps at EI02. My evidence sets out the ways in which this objective, insofar as it applies to the national grid, does not give effect to the NPSET. I'm also of the view that the outcomes described in the objective are at odds with the implementing policy EIPX for the national grid. I've suggested that the objective be recast to be sort of higher level or less detailed so that it achieves that consistency with the implementing policies and also gives effect to the NPSET. I've done this by suggesting a national grid specific clause so that there are no consequences for other infrastructure. And I note today that Ms Seaton said that was good for the national grid but didn't necessarily deal with the port's issues that are similar to the issues I identify for that objective. I also note that the planning witness for DOC supported the national grid specific clause in that objective. You also had a brief conversation today around the use of the phrase no practicable alternative locations. And in that regard, given that its genesis is from the NPSIB, I just want to highlight that the NPSIB doesn't apply to the national grid. National grid's explicitly excluded from those provisions, and therefore to apply a test from that national policy statement to the national grid ought not be done, I guess, is what I'm saying. Turning to objective EI04, my evidence primarily opposes the use of the words incompatible activities. I set out in my evidence the relevant higher order provisions and conclude that these provisions direct that all subdivision use and development is managed in the vicinity of the national grid rather than just incompatible activities. I do think there's a distinction in the way that's expressed, and it suggests that compatible activities aren't managed by the provisions, and I don't think that's the scheme of both policy EIP3 and the subsequent rules. And at paragraph 45 of my evidence, I set out the amendments that I support to that objective. In terms of EIP1, my evidence supports amendments to distinguish the enablement of operation, maintenance, repair, removal and minor upgrading, and then provides for new or more than minor upgrading to infrastructure or important infrastructure in that regard. I rely here on policy 5 of the MPSET that directs the enablement of minor upgrading, operation and maintenance, whereas policy 2 of the MPSET distinguishes that with a recognise and provide direction. And again, I question the reference to appropriate locations in this policy. And I think that referencing locations somewhat detracts from what is important, being the management of the effects of the activity. And in that regard, I see that infrastructure could be in locations and have no effects on the values of that location. And I'm thinking one really good example of this is where transmission line conductors traverse a significant natural area and they don't touch the area, affect the habitats or valued indigenous vegetation, but in that location in any case. And then lastly, EIPX, which is the recommended new National Grid specific policy to address the effects of the national grid. I generally agree with the drafting there. I've set out the differences between Transpower's submission and the drafting in the 42A report and have only highlighted one area where I suggest a change, and that's wording to reconcile the enabling higher order provisions in respect of the national grid with the NZCPS. And I promoted an approach that's generally consistent with similar provisions in other jurisdictions. Lastly, I note in terms of stormwater policy P3, Mr. Willis has agreed with amendments that I suggest to that policy, and I note also that Ms. Seaton was supportive of those provisions, or that amendment, I should say. The last matter I want to address is in the subdivision section 42A report. My evidence considers objective DV01 and DV03 and concludes that these provisions as recommended for amendment do not give effect to the MPSET. Now, Mr. Boys in his summary statement to you responds to my evidence by stating that the relief sought by Transpower is not supported because the land in question is anticipated to be for development for residential and urban development purposes, and that Transpower's relief could be used to frustrate what is otherwise provided for by the planning framework. I don't agree with this statement because in the case of Bruff Scully, that area was a development area through Plan Change 21 to the operative plan. And in that plan change, there was explicit provision for the avoidance of adverse effects on the national grid. So even in making the area a development area, there was always the acknowledgement that where the national grid is, activities should be avoided. So Transpower's submissions effectively seeks a continuation of the same level of protection for the national grid. I also think that the fact that both areas are development areas doesn't negate the need to give effect to policies 10 and 11 of the MPSET. And in fact, given that there's development anticipated in these areas, giving a clear direction in respect of the protection of the national grid is timely and important to ensure that that development is designed around the constraints imposed by the national grid. Now, all of that said, the summary statement proposes further amendments to the objectives. And in my view, these amendments would give effect to the MPSET. And the summary statement also indicates that these could be subject to further discussions with Transpower, and I'll just signal now that I'm more than happy to participate in those discussions. And I've considered those amendments alongside the relief sought in my evidence, and this is at paragraph 91. And I'm still of the view that the most succinct approach may be to cross-reference the more detailed policy EIP3 that also gives effect to the NPSET and provides direction for the protection of the national grid throughout Timaru. And I don't consider that there's a need to provide a differing direction in the development areas compared to the district as a whole. I support a approach that provides for consistency within the plan and reflects the district-wide approach to implementing this protection and the rules that follow the policy. So that's my summary. I'm very happy to take questions.
Thank you, Ms McLeod.
Jane, can I start? I actually want to make questions.
Oh,
my question. Thank you, Ms McLeod. I noted that you had been tuning in to Prime Port's presentation today, and in particular Ms Seaton's planning evidence and summary. I wanted to ensure that I had understood your response to her evidence. In relation to EI01, Objective 2, Ms Seaton stated that while she agreed with Ms Francis from ECAN around consistency with the NPSIB, she disagreed that the wording "no practicable alternative locations" is necessary to ensure consistency with the Canterbury Regional Policy Statement, as the assessment of functional or operational need can sufficiently encompass assessment of that location. Are you able to comment on that for me in terms of your reaction to that statement, or is that a point of difference that we need to explore further?
I think we generally agree. I think in relation to the national grid, firstly, there's the difference in terms of the national grid being excluded from the NPSIB and that test of no practical alternative locations. But setting that aside, I do agree with Ms Seaton that where you have a test around the operational need and functional need for a particular type of infrastructure, that very much requires a test about why something needs to be in the place it is, and allows the council to interrogate that in any future consent or designation processes.
Thank you, that's helpful.
No, that's been really helpful, and thank you very much for your summary statement and additional comments. Thank you. The panel, just in terms of the stormwater matter, we will issue a written direction around conferencing, but in the meantime, it would be useful to receive from you a list of who should attend that conferencing for us to have a look at as well. Given the way that the issues were sort of articulated in the Port's submission this afternoon as well, it may be that the issues are quite a lot narrower than what they might have appeared to us at the outset. So it might be quite a short conference, but I think it does deserve some contribution, both from obviously Mr Willis, but from the submitters who are directly impacted by that chapter. So if you could attend to that. And one of the other tools that we think would find useful relating to the sites and areas of significance to Māori is we're trying in our minds to work out a very succinct way of identifying what the rule implications are for each of the SASMs, and how they relate to, firstly, the underlying zone consent requirements, so trying to identify what the additional consent requirements would be for being within one of the SASMs, and also the consent requirements for each of the other overlays in the ecosystems and landscape provisions, so ONLs, etc. as well, and also, to add another complicating factor, any regional council. That's a bit of a brain dump. We've been trying in our own minds to work out how might be the best way to represent in some form of matrix a way in which we can compare what the regulatory controls are for each of those, the base zone, add in your SASM, what does that do, what's the difference, and the other overlays as well. So I had to talk to my planning experts on the panel who think a little differently than I do around articulating these issues. So happy for them to chip in about how they envisage that might occur and whether we can draw on council to reporting officers to assist us with that exercise. So did you want to have a crack at that?
If I start, and then my colleague at the end of the table can re-correct me. The issue is it's a lot of information, and in one matrix, I just think we're going to struggle to make it work and be evident. And so what we were wondering about was whether, if you're focused on the particular activities that are key within the SASM, so for example, it was the forestry, the earthworks, and mining and quarrying, and was there another?
I think it should encompass all of the activities in the notified version, so we can understand that as well. So it would pick up the intensive farming, and
yes,
also the structures
and the temporary activities. So if we focused on so for each activity, if we could then understand what the different layers would mean for that activity. And it may be that isn't the most practical way, but when we were doing it, do you do it with the zone first? It just got very complicated. So we think focusing on the activity itself and then understanding how each layer or each SASM and then each of the other overlays influences that activity. I think that would give us the information we're hoping to ascertain.
Could I just clarify? I think you said that you want that for the notified provisions.
We're still in the position where we have a notified plan and we have rules that have immediate legal effect. So from a submitter's point of view and from our starting point in terms of evaluating at what was notified, and it still may be on the table that the notified version is preferred over the recommended version. It's still, but what we're trying to understand is what's the difference between the rule that applies to a, say, standard general rural zone, earthworks, take that for an example. Okay, what's the status of the activity under that zone as notified? Apply any relevant overlay. What are the changes in activity status that apply to that same activity? One of the issues that's come up across the hearing is, is there already a consent triggered for a particular land use within the zone before you even get to a position of considering what the overlay is. It's going to help, we think it's going to help us understand what what's the most appropriate regulatory tool to provide for the values within those zones, what's the most efficient, and identify whether there are any duplication. And we do appreciate that that's an exercise that you've endeavoured to do through your reporting, but we need to be able to have that information in front of us without spending, flipping through several chapters of the plan, trying to fill in a matrix ourselves. Now, as a panel, we've had a good go at that, but we're not entirely sure that we've got it right, and we would be assisted if you could do that exercise for us. So does that That makes sense. We're not asking you to do something that's unrealistic.
No, I don't think so. I just want, it was just clarification of exactly what you were wanting the comparison with.
So our thinking was to start with the activity and then provide the information across the,
I guess just saying, if there is a difference that the recommendation would completely alter it, that is also fine as a, to reflect that.
Yeah, that's partly why I asked that question because, and I think you alluded, a number of the recommendations have been made because I think there is duplication there, and it was to try and avoid that. So to my mind, the matrix with the notified version will show you, in my opinion, quite a lot of duplication, and whereas comparison with the recommendations, I think, will hopefully would show you a slightly clearer, less duplication and therefore clearer about what's applied through each.
Well, we're going to, I'm wondering though that we'll miss an entire activity category in terms of the intensive farming activity if we don't encompass that in a table somehow. So if you can add another line or a note or change the colour of it that identifies that this notified provision has recommended to be amended and reflect what the amendment provision is, that will make that absolutely clear. But
I can just do it in a way that's quite clearly distinguishes between what's notified and if there's recommendation is how that alters that.
Is there any complication about changes that have been made or recommendations that you've made around the overlays and the zones as well? Like in the sense that if we're reflecting the notified version of SASMs, are there changes to those activities as a result of your recommendations from the overlays? Like, do we need to use the notified version of the overlay provisions in the notified version?
That's essentially what they're saying is for all the overlays, including SASM.
Okay.
That's I understood.
So the zones and the overlays for everything will be based on the notified version, even though there might be recommendations to make changes.
And then just then identify those recommended changes. It is a bit of work, but we feel that that is a way that we can be very clear around where the movement is and identify where those overlaps might be and assist us to reflect on the appropriateness of the rules that have been both notified and recommended. It also seems to be a bit of an area of confusion or misunderstanding by some submitters too about understanding what the implications are of the overlays for their existing farming activities or their future land uses vis-a-vis what would occur anyway without the overlays. So multi-purpose, useful document for us to see as part of our deliberations. Thank you. Now, I had there was just some minor matters I think we'd picked up from previous hearings. There was some additional advice, Ms. White, that Mr. Harding provided to you in the context of your reply on hearing D, which I don't think we have a record of. So I don't know in what form that advice was received and if it can be made available to the panel.
Yeah, my recollection is it might have been a series of emails, but what we can do is essentially package that up into a memo or something similar.
Okay. Now, I'm just going to check is there anything specific at this point, Ross, that you... The panel's going to work on a minute, which is basically those more technical questions that we didn't ask during this, sort of getting down into the detail of some of the drafting, and we'll go through a process of reviewing our notes on those and culling any that have been resolved through this week, and then issuing those in a minute and giving you an opportunity to reflect on those, and we'll do that quite quickly so that it's part of reply. Oh, yeah, well, that's just a follow-up. And another matter for you, Ms White, was during the hearing we talked about Appendix 5A and 5B of your report. And, can we check in with you in terms of the timing of that information and the availability of that? We would prefer to receive that before your interim reply.
That's fine. I had assumed it would be part of the reply, but there's no issue with doing that.
I think it's a matter that's come up in submissions as well, and I think that we would like to receive it and for it to be available to submitters as well before we have a specific reply from you, because there will likely be some questions that will arise out of that for you and Mr Henry potentially, and we'll need to think about what the process is for a response to that, and particularly if it raises any issues that we need to be mindful of in terms of any public process. We would like the opportunity for that to be carefully considered. So the timing of the interim reply, we've got a bit of time now before the next hearing, so there's no great rush from our perspective to get the reply, but we're conscious, as always, of the mounting workload that you have moving into the next hearing phase as well. So happy to hear from you what your thoughts are on a time frame for an interim reply.
Sorry, Madam Chair, we were just looking at the date for the next hearings reports, which are to be published on the 24th of March. And our preference has always been to do the replies after we get those reports out the door, but then I'm also conscious that we're moving towards, Easter-ish. And I apologise, I should have checked this before coming up here. I'm just checking the Easter holiday date. It's April the 18th, so we could probably fit them into, say, around the 15th to 17th of April, which would give us another, say if we said the 17th of April, that would give us another 2 weeks after those reports are due. Oh, actually, sorry, that would give us 24th, 31st. Yeah, that gives us a couple of weeks, 2 or 3 weeks.
That's us. Fine.
Thank you.
So we'll aim for the end of that week.
The 17th is the Thursday, Good Friday's the 18th.
Yeah, be perfect. Okay. Was there anything that you wanted to raise with the panel just before we close out today?
So only to say I've kept a reasonably good list of our homework. I'm happy to send that through to Ms Thorne if that would help. You've got a couple of questions for me as well as for the 42A officers. I just wanted to bring your attention to a couple of things. And the first thing is just to mention that there are a couple of cases that I referred to in my legal submissions that might be useful just in terms of some of the submissions that were made over the last couple of days. The first one is the Rakes case, and that I didn't address this in my legal submissions, but it did deal with some arguments around the sort of spiritual connection of landowners or spiritual or religious beliefs of landowners as compared to the Section 6E sort of requirement to recognise and provide for the relationship with ancestral lands of mana whenua. And I don't want to make an extensive submission on that, but I just wanted to point out that there is some case law around that. Essentially, the Environment Court, that was a High Court case, it confirmed the Environment Court approach, which essentially said, while everyone's beliefs are to be respected, the RMA requires decision makers to specifically recognise and provide for the relationship of iwi, and that the High Court said the Environment Court rightly put aside the religious beliefs of the landowner in making its determination. And so I think just taking that kind of the next step, if you think about the policy rationale for Section 6E, it essentially appears to elevate the rights of, or the relationship of iwi in that section because of the fact that the ability for iwi to continue to use land for travel or collecting mahinga kai or whatever have been disrupted or displaced by private property rights. So in a sense, the system upholds private property rights by enabling that continued recognition of the relationship of iwi with the land while not disrupting private property rights at all. So I think that could be useful in your consideration. And the other case, and again, I don't necessarily think you need to go here, but just in terms of the comments that Commissioner Mackay made in response to the submission today, is it might be worth just having a look at Justice Whata's decision in Ngāti Maru Trust and Ngāti Whātua Ōrākei. And in that decision, he said that obviously RM decision makers aren't entitled to make determinations about mana whenua status generally, but obviously when it comes to Section 6E, if there are competing claims of mana whenua...
I think you can take it that we're well aware of that case.
I just wanted to make sure that you...
Key part of our training as commissioners.
Okay.
I don't... Yeah.
Great. Yeah, I just wanted to make you aware. It's the reference is there. I'm happy to provide any of those cases or others if that would help.
Reach out if that's useful.
Thank you
for that.
Kia tau ngā manakitanga a te minaro, ki runga ki tina o tātou, kia mahia te hua ma kihi, kia toi te kupu, toi te mana, toi te araha, toi te reo Māori, kia tūturu ka whakamaua kia teina, haumie, huie, tākie.